And as I've indicated to you throughout the trial, the statements of counsel are not evidence. You have heard all of the evidence and seen all the evidence in the case. And at this point, what the lawyers do is comment on the evidence, give you their interpretation of the evidence that you've heard. Ultimately, you are the judges of the evidence. You determine what happened in this case based on the evidence that you've seen and heard in the courtroom. But the lawyers obviously have important things to say as to how they interpret the evidence. And the argument will proceed first with prosecution, then defense, both defense counsel, then the prosecution has a chance to complete argument. And hopefully by Friday, argument will have been completed, and I will instruct the jury on all the legal rules, and then you'll begin your deliberations. All right, you may proceed.
Thank you. I'd like to reiterate what the judge just told you. This has been a very long trial, and I will make mistakes in reciting to you the evidence. I don't think there's any chance I won't make some mistakes. And if your view of what the evidence was conflicts with what I tell you, obviously it's your view, because you're the ones who are now going to decide this case. And so keep in mind that this has been a long trial, and that what we say is meant to persuade you. It's not meant to, it's attempted to be 100% accurate, but I can't guarantee that it will. And in light of that, I'd like to point out that 17 weeks ago this Friday, 17 weeks, the people of the state of California rested their case. It was August the 13th of this year, and August was a very long time ago. At the time that the people of the state of California rested their case in chief, this was a murder trial. And as soon as the defense of the case began, it became anything but a murder trial. What I'm here to tell you today is that you have to concentrate now on the murders of Jose and Mary Louise Menendez. I have up on the board an exhibit which is number 7, and I'm not going to discuss a lot of the exhibits with you, but you're going to have over 200 exhibits for your perusal if you need them during the course of your deliberation. But the exhibit on the board is why we are here. We are not here to discuss whether or not Dr. Oziel should be sued for palimony by Doodle Smith. We are not here to try Mr. and Mrs. Menendez for being bad parents. We are not here to try Jose Menendez for being an alleged, not a convicted, but an alleged child molester. And we are not here in the psychological malpractice trial of Dr. Oziel. What's going to happen at the end of argument, I'm going to try to restrict my argument to the morning session, but I may go a little bit into the afternoon. And the defense attorneys will then argue to you, and then I will have a chance to argue again. At the end of our arguments, the judge is going to instruct you on the law. And you're not going to get any law dealing with child molesters or bad psychologists or bad parents. The law that you're going to get deals with homicide. It deals with murder. And that's what this trial is. It is a murder trial. When the judge instructs you on the law, he's going to instruct you on 4 theories dealing with homicide. And I'm going to use charts, not too many of them, to try to illustrate what you're going to hear from the judge. As I just said, this is a trial dealing with homicide. And homicide is very simple. Homicide is that a human being was killed, that the killing was unlawful, and that the killing was done with malice or forethought. This is the law of murder, all right? And it's the people's contention that this is a murder trial. This is not a manslaughter trial. The defense attorneys are going to argue to you the law of manslaughter. But what I need to point out to you right away is that there are only 4 things that you could convict this defendant of: first-degree murder, second-degree murder, voluntary manslaughter, or involuntary manslaughter. There is no theory by which you can acquit this defendant. There is no legal theory by which you can find Lyle Menendez not guilty. So keep in mind during your deliberations that in order for you to find him not guilty, you would have to ignore the law in this case. The judge is going to instruct you that this is either first-degree murder, second-degree murder, voluntary manslaughter, or involuntary manslaughter. Those are your 4 choices. You will be getting a not guilty form, but in order to fill out that not guilty form, you would have to ignore the judge's instructions. Now, you're going to get some other instructions in this case dealing with the law of conspiracy, and you're also going to get some instructions that deal with things called special circumstances, and I'm going to discuss them in the first part of my presentation. Premeditated first-degree murder, and I don't have a chart for that because it's a very long definition, but basically premeditated first-degree murder is where you kill someone, you plan to kill them, you think about it, and you do it anyway. Premeditated murder, the judge will instruct you in as I said, a rather lengthy instruction, but you all have an idea in your heads of what premeditated murder is. Premeditated murder is when you think about it, you plan it out, you carefully weigh and consider it, and you do it kind of cold-bloodedly, and that is premeditated first-degree murder. The only theory of first-degree murder that the people are going to urge on you is this theory, which is premeditated, cold-blooded, calculated murder. Let me read to you part of the instruction. If you find that the killing was preceded and accompanied by a clear, deliberate intent on the part of the defendant to kill, which was the result of deliberation and premeditation, so that it must have been formed upon pre-existing reflection and not under a sudden heat of passion or other condition precluding the idea of deliberation, it is murder of the first degree. What the defense will argue to you is that the defense theory of the case means that there is no premeditation. They're going to argue to you that the events that occurred between August the 15th and August the 20th clearly show no premeditation. So that's one of the key points that we're going to be arguing over. This particular instruction goes on to say that the true test is not the duration of time, but rather the extent of the reflection. A cold, calculated judgment and decision may be arrived at in a short period of time, but a mere unconsidered and rash impulse, even though it included an intent to kill, is not such deliberation and premeditation as will fix an unlawful killing as murder of the first degree. The slayer must weigh and consider the question of killing and the reasons for and against such a choice, and, having in mind the consequences, he decides to and does kill. It's very specific as to what constitutes premeditated murder. The people of the state of California have proved to you that Lyle Menendez, accompanied by his brother, planned this murder. I would like to refer you again to the tape from December 11th, which was played for you near the end of the trial by the defense. But in that tape, where you hear the voices of Dr. Oziel, Lyle Menendez, and Eric Menendez, you hear Lyle Menendez, unprompted by Dr. Oziel, talking about planning and planning to kill. And he talks about the fact that he gave his brother a couple of nights to sleep on the decision to kill Mom. And implicit in that is that it was a decision to kill Mom that was coldly and carefully arrived at. Now, the defense is going to tell you that what happened is these defendants were in a constant and heightened state of fear between the 15th of August and the 20th of August. But the evidence in this case, not the defendant's words, but the physical, circumstantial evidence in this case, disproves the defense theory. I'll get into that some more later. The second kind of murder that you're going to hear about is murder of the second degree. May I have some water, please?
Yes, certainly.
Thanks. Second degree murder is still murder. Society recognizes that when you kill someone, there are all different reasons and kinds of killings. Second degree murder is a murder, that is a crime that's committed with malice aforethought. But it's not premeditated. It's something that occurs with less forethought, with less calculation, and with less care. Now, there are two theories dealing with malice aforethought and the way that it applies to second-degree murder, and I'll tell you what that is. Malice aforethought is either express or implied. And this particular thing that I'm going to read to you deals very specifically with second-degree murder, which, again, is unpremeditated murder. Malice is expressed when there is manifested an intention unlawfully to kill a human being. Malice is implied when the killing resulted from an intentional act, the natural consequences of the act are dangerous to human life, and the act was deliberately performed with knowledge of the danger to and with conscious disregard for human life. When it is shown that a killing resulted from the intentional doing of an act with express or implied malice, no other mental state need be shown to establish the mental state of malice aforethought. The mental state constituting malice aforethought does not necessarily require an ill will or hatred of the person killed. Keep in mind that malice, the way you might use it in your ordinary language, is not the same as the legal definition of malice. The word aforethought does not imply deliberation or the lapse of a considerable time. It only means that the required mental state preceded rather than followed the act. Now, in this particular case, it's the people's theory that second-degree murder does not apply to the facts. This was an intentional killing that was planned. This was not an act that just occurred at the spur of the moment without planning and calculation. And again, I will discuss with you a little later what the elements that we feel show that this was premeditated versus something that was done on the spur of the moment. The next theory of homicide that the judge will instruct you on is voluntary manslaughter. And this, I believe, will be where the defense will concentrate their argument dealing with the law. Voluntary manslaughter is where a human being was killed, the killing was unlawful, and the killing was done with an intent to kill. Voluntary manslaughter is of two kinds. There's voluntary manslaughter where there's been a sudden quarrel or heat of passion. I think the classic case of voluntary manslaughter is a person finding their spouse being unfaithful to them right in front of them. And in the heat of the moment, the person kills their spouse. Or, if you want to be really fair, kills the spouse and the person with the spouse. That's a classic case of heat of passion. The other thing that you're going to hear about is another theory. It's a theory of manslaughter that reduces a murder to a manslaughter, and I will discuss this with you now. The key to the defense case, and I think the reason that you heard the kind of evidence that you heard, is so that the defendant will be convicted of a manslaughter. Now, one of the theories is heat of passion and provocation, and the defense attorneys will argue to you that the lifetime of abusive conduct by their parents fed them and fed their fear so that the events which occurred between August the 15th and August the 20th make sense. And what the defense wants you to do is to convict their client of voluntary manslaughter, or better yet, of involuntary manslaughter, based upon this particular instruction, which is a person who kills another person in the honest but unreasonable belief. Now, keep in mind, it's got to be an honest belief. In the necessity to defend against imminent peril, keep in mind the word imminent here, to life or great bodily injury, kills unlawfully, but does not harbor malice aforethought, and so is therefore not guilty of murder. This particular instruction is used to reduce a murder to a manslaughter. Now, keep in mind, these instructions are very difficult. Murder instructions are the most difficult of them all. And so it may take a while for these concepts to sink in. Took me a long time to figure out the difference between these different kinds of killings. To continue on, this would be so even though a reasonable person in the same situation, seeing and knowing the same facts, would not have had the same belief. In other words, if you sitting here in the jury box look at the facts in this case and you think, I don't understand why they did what they did, I wouldn't have acted that way. Still, the standard is whether the defendant honestly but unreasonably believed in the need to defend himself from imminent peril. Such an honest but unreasonable belief is not a defense to the crime of voluntary or involuntary manslaughter. Now, what this last sentence here means simply is that if you have a killing and you are saying that you honestly but unreasonably believed in the need to defend yourself, then the killing is either a voluntary or an involuntary manslaughter, but it's not guilty. So this particular concept of an honest, unreasonable belief in necessity of self-defense as to imminent peril means that the defendant is not convicted of murder, but he's convicted of either voluntary or involuntary manslaughter. So your four choices, again, are first-degree murder, second-degree murder, and second-degree murder really is, it's not a manslaughter, and it's not premeditated murder, but it's a killing with malice aforethought. And to me, and it's always seemed to me that that's a little bit hard to fathom, but if you look at it as being a intentional killing, or a killing done where you're shooting at someone and you should know that you're going to hit someone, because anybody would know that if you shoot at, or if I started shooting at a room full of people, I may not have premeditated it, but that act is so callous that I am going to hit someone and someone's going to be hurt. Or if you take your car and you drive it into a crowd of people, you may not intend to kill a particular person, but that act is so dangerous that malice is implied from the doing of the act. Now, the defense may want to argue that by going into the family den and shooting at the parents, that this is only a second-degree murder because the defendant really hadn't premeditated and really hadn't thought it out. But I submit to you that the evidence in this case of premeditation is very strong. The other instructions, now you're going to get some other instructions, and one of the things that you're going to be told that is that the people have charged a conspiracy. See, count one in this case deals with one parent, count two deals with another parent, and I'd like to point out to you that in spite of the defense efforts to commingle Mr. and Mrs. Menendez into one person, and in other words, they were the united front confronting these defendants, they are two separate people. They are two separate human beings, and you have one count of murder for one and one count of murder for the other. And I would ask you to pay particular attention to the fact that there are two human beings here who were killed, and in spite of the defense protestations to the contrary, they may have been killed for very different reasons. The third count of the indictment is a conspiracy to commit murder. Conspiracy to commit murder and the lesser offense of conspiracy to commit voluntary manslaughter is as it sounds. And what we've alleged is that in order to prove that there was this agreement among the defendants to kill their parents, on August the 18th, they purchased 2 Mossberg shotguns in San Diego. Well, we know that's true. They admitted it on the stand. But before they admitted it on the stand, the people proved it. The second thing is that on or before August the 20th, they acquired shotgun ammunition. The testimony of the two defendants is that on Saturday morning, the 19th of August, they in fact went to Van Nuys and acquired further shotgun ammunition in order to kill their parents. So that particular overt act has been proved by their own testimony. And the last thing is that on August the 20th, the day of the murders, Lyle Menendez contacted his friend Perry Berman by telephone to arrange a meeting later that night to serve as an alibi. Now, the defense is going to give you explanations for why all these things don't look as they do look. It's kind of like if it walks like a duck and it quacks like a duck and it has feathers, it's a duck. The defense is going to try to tell you that the duck in this case is really a donkey, but that's not correct. In this particular case, the people have proved each one of these overt acts, not only because of what the defendant said, but because of the people's own evidence. So you will get a form that will talk about conspiracy, and you will have to decide whether this is a conspiracy to commit murder, whether it's a conspiracy to commit voluntary manslaughter. The people's theory is, of course, that this is a conspiracy. It's an agreement among these defendants to go out and slaughter their parents. This is not a heat of passion killing. This is not a killing with an honest but unreasonable belief in the need to defend. This is a first-degree premeditated slaughter of two people. Now, the people's theory of the case is not that the defendants saw money, saw their parents standing in the way of money, and so killed their parents to get the money. That kind of killing, a killing for financial gain, is more appropriate where, for instance, you don't love your spouse too much and you take out $1 million life insurance policy on your spouse. You wait a couple weeks after the policy is in effect and you kill your spouse. That's a classic murder for financial gain. This is not a classic murder for financial gain. This case, the motivations in this case are more subtle than that. Now, the judge is going to instruct you that motive need not be proved. In other words, I don't have to prove to you what the motive for the crime was. All I have to prove to you is that this is a premeditated murder and that it's not a murder in the heat of passion or with this honest but unreasonable belief. All right, so motive is not anything anyone has to prove, but motive is also often very helpful because people want to know, jurors want to know, why did these people do this crime? In this particular case, the reason the crime was done was not simply to get money. The reason the crime was done was because the defendant, specifically this defendant and his brother, wanted to maintain their life in the way it was without their parents telling them what to do, without their parents controlling them, without their parents possibly disinheriting them and making them go off on their own. And so if you look at the conduct of Lyle Menendez after he slaughtered his parents, you will see conduct which carries forth that purpose. He didn't want to go to Princeton, so he didn't go back to Princeton. He wanted to be a businessman, so he bought a restaurant. The testimony of Charles Wadlington, his coach, the testimony of Donovan Goudreau, his friend, indicated that he wanted to own a restaurant. Mr. Wadlington said when he coached him at the age of 15 that he talked about wanting to own a restaurant. Mr. Goudreau indicated that they used to go eat at Chuck's Spring Street Cafe and that Lyle Menendez talked about how it would be a neat place to own. And so what happens? The first thing he does, he goes out and he buys a Rolex watch. He buys a $70,000 Porsche. He buys a restaurant. He buys homes. He emulates his father, but without his father's control. And so to say that this is a murder strictly to get money is to misunderstand the motivation of the defendants. It's a lot more, it's got more components to that than just to say they wanted money. Because if they wanted purely money, there are other ways they could have gone about getting the money. What they wanted was their lifestyle. They wanted freedom. And they wanted to be free from the idea that their father would somehow disinherit them. And pervasive through this case is the notion that in the spring of 1989, Mr. Menendez was not happy with Lyle Menendez. Lyle Menendez had struck a deal with his father that he was going to do better at Princeton, but he didn't. And when he came home from Princeton that summer, the family got a couple of notices about the fact that Lyle had once again not performed up to expectation, that Lyle had gotten in some trouble over a party, and the father was going to have to make some payments because of this party. Lyle Menendez was not even keeping his end of this bargain where his father had reduced his expectations and told him, just pass. I don't expect good grades. I don't expect graduate school. Just pass. Just get through Princeton. And it was beginning to look like he couldn't or wouldn't, and I think wouldn't is probably the better word, even do that. Now, there are two other things that you're going to be asked to do at the end of filling out these verdict forms. You're going to have special circumstances to find. Special circumstances are those things, they're special allegations. And they deal with this particular kind of crime. And there are two special circumstances in this case, and the first one's very easy. It's multiple murder. If you find that one of the murders was a first-degree murder, and the other murder was either first or second degree, then this multiple murder special circumstance should be checked off by you as being true. Now, if you find 2 counts of first-degree murder, that satisfies it as well. But 1 count of first-degree murder and 1 count of second-degree murder means that the defendant should be and has been convicted of multiple murders. The second particular special circumstance deals with murder while lying in wait. Lying in wait, the judge is going to give you a rather lengthy instruction about lying in wait. But basically what it says is, and I'm going to read you part of it right now. For a killing to be perpetrated while lying in wait, both the concealment and a watchful waiting period, as well as the killing, must occur during the same time period or in an uninterrupted attack commencing no later than the moment concealment ends. Now, lying in wait traditionally is thought of as an ambush killing. For instance, I decide I want to kill one of you. I find out where you live. I hide behind a bush. I wait for you to come home. When you come home, I jump out, I get my gun, and I shoot you dead. That is a classic example of murder by lying in wait. I am lying in wait, I'm concealing myself from you, I'm concealing my purpose from you, and I'm taking you from a position of advantage and surprise. But ambush, which that is not the only kind of lying in wait. Ambush is kind of the idea where the victim comes to where the killer is. But in lying in wait in California, the killer can go to where the victim is, and it still constitutes lying in wait. For instance, if you are in a room and the doors are closed and you're minding your own business watching TV and you're taken by surprise by your two sons, that satisfies some of the requirements of lying in wait. If there is a clear, and I'm again reading, if there is a clear interruption separating the period of lying in wait from the period during which the killing takes place, so that there is neither an immediate killing nor a continuous flow of the uninterrupted lethal events, the special circumstance is not proved. In other words, if I'm hiding, waiting for you to come home, and I get bored, and I go and I get a cup of coffee, and then I see you, and I see you on the street, and I just go kabam, that's not a lying in wait. A lying in wait means that that the concealment and the unlawful activity is continuous and uninterrupted. Again, I'm reading, a mere concealment of purpose is not sufficient to meet the requirement of concealment set forth in this special circumstance. However, when a defendant intentionally murders another person under circumstances which include a concealment of purpose, a substantial period of watching and waiting for an opportune time to act, and immediately thereafter a surprise attack on an unsuspecting victim from a position of advantage. Those are kind of the crucial words there. The special circumstance of murder while lying in wait has been established. If the murder is done suddenly without a period of waiting, watching, and concealment, the special circumstance of lying in wait is not present. All right, what this is saying to you is that in addition to being a premeditated first-degree murder, that this murder was committed by means of lying in wait. In other words, first you'd have to find that it was a first-degree murder, and then you would have to find that this murder was done by means of lying in wait. Well, in this particular case, if the people's theory is to be believed, and of course I'm going to urge that it should be, these particular requirements have been met. And therefore, this special circumstance, as well as the multiple murder special circumstance, should apply. Now I'm going to briefly go over with you a few of the standard jury instructions that you're going to get. One of the things the judge tells you is he tells you the different theories of murder and manslaughter. He also tells you things you should do and shouldn't do. He also tells you how to evaluate the witnesses in this case. One thing I'd like to point out to you is, once a defendant takes the witness stand, his testimony is governed by the same rules as every other witness. In other words, you should apply the same standards and scrutiny to the testimony of a defendant who's testified in court as to any of the people's witnesses or any of the other witnesses for the defense. They're all witnesses. And the judge is going to give you jury instructions, which I'm not going to read to you, that deal with how you evaluate witnesses. Let me go through these briefly. One of the things the judge will tell you is that neither side is required to call as witnesses all persons who may have been present at any of the events disclosed by the evidence. So keep in mind that there's no legal requirement that all the witnesses who might know anything about this case be called. If that were the fact, we would be here another year. You're also going to get an instruction on prior consistent and inconsistent statements. Prior consistent statements are statements of a witness that were made that are prior to being in court that are consistent with that person's testimony. An example of that would be when you heard the KABC Michael Jackson tape of Grant Walker, where he called in and said, "This is Fred. I was there the day before the homicides. I'm here to tell you that it didn't occur the way you people think." That statement that he gave was essentially consistent with his testimony in court. That is an example of a prior consistent statement. It's an out-of-court, meaning outside the courtroom statement. And then an inconsistent statement is a statement from outside the courtroom as well. That would be at another hearing or at another time. That is inconsistent. That it means different from the witness's testimony. And a classic example of inconsistencies in this case would be the testimony of Judalon Smith. to try to dissect her testimony as to what is consistent and what is inconsistent would require more time than any of us would want to deal with it. But as an example, Ms. Smith took the witness stand, and on several occasions I read to her statements that she had made either in a different courtroom or in an affidavit that she'd filled out. Those statements were sometimes consistent with her testimony and sometimes inconsistent. And at times her testimony here in this courtroom from day to day was either consistent or inconsistent with what she was willing to say at any given time when I was questioning her or when Mr. Burt was. So that's an example. When the attorneys get up and they say, well, isn't it true that on a prior occasion you said blah, 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 and here in court you're saying something different? That is an example of an inconsistent statement, and you can consider those for whatever value you think they serve. The judge is going to read you an instruction called Credibility of the Witnesses, where he tells you what things to look for. Two of the things I'd like to emphasize is when you're looking at a witness, you look at the existence or non-existence of bias, interest, or other motive. Now, in this particular case, I'd like you to apply this certainly to the defendants because they have a bias, interest, or other motive in testifying. And I think we all know, and I think it's been driven home, that their bias and interest and motive is not to be convicted. I mean, they desperately don't want to be convicted. And the other bias, interest, and motive, I think, goes to the relatives, especially the relatives of the defendants. I think that the relatives were basically sincere when they came forward and talked to you. And I'm not going to stand up here and tell you that they lied because I don't believe that they did. Some of their testimony was exaggerated. Some of it was hard to believe. Marta Cano, I think, would probably be at one extreme, and Terry and Carlos Baralt would be at the other extreme of the relatives in this case, leaving aside Brian Anderson, who, of course, testified for the prosecution. But I think that their motivation was probably, in their own minds, good, and that is they're here to save the defendants. There is nothing that will bring back Mr. and Mrs. Menendez. And in the minds of the relatives, I can see that it's very logical to assume, well, we can't bring them back, so let's save their sons. And I think that that is a very human emotion. I think for people to feel that way is very understandable. But keep in mind what's been painted for you here is a very dismal and awful picture. And keep in mind that these relatives often sent their children to stay at the Menendez home for more than a day at a time. Some of these people sent their children to stay at the Menendez home for weeks, months, and years at a time. And yet, they come into court and they malign the parents as if they were Hitler, that they had sent their children knowingly to a concentration camp where their children and the defendants were treated hideously. What the defense has done is they've taken selective incidences, jumbled them all together, and made it look like the Menendez home was one constant horror. If in fact the Menendez home was one constant horror, then ask yourself why these people who knew about it, because they came in and talked about it, why would they have sent their children there all these different times? What's been attempted here is to paint a very, very negative, awful picture. And I'm not going to stand here and tell you that I wish these people had been my parents. I'm not going to say that they were wonderful, wonderful parents. They obviously had terrific flaws. Most people do. And think about yourself. Think about if someone wanted to paint you in a very bad way. Think about things you've done in your life and take all the little bad things you've done in your life, because everyone's done them, and put them all together without any way to say about anything about the good things. And if you put them all together and you only see bad, then that's the picture that's going to be painted. Obviously, these people were flawed. They loved their children, but they pushed their children. And perhaps they pushed, well, I think it's obvious they pushed their children too far because their children killed them. But to say that these people were the monsters portrayed in this courtroom belies human nature. Human nature being what it is, these relatives who came in here and so maligned the dearly departed when they were alive, they were more than willing to take advantage of their hospitality and their generosity. They were more than willing to spend time with them, to send their children to them. Diane Vandermolen spent a year, I think 13 months during one stretch of her life in the Menendez home. But her mother comes in and says bad things about her sister. And parenthetically mentions the fact that she took clothes out of her sister's closet after her sister died, because after all, they were the same size. So keep in mind that these people, while I'm not going to urge to you that they were liars, they certainly have a bias or interest in this case. The other thing that I'd like to point out that the judge is going to talk to you about is evidence of the existence or non-existence of any fact testified to by the witness. What does that mean? That means when Eric Menendez and Lyle Menendez testify that they went to the Big Five and they were about to purchase handguns and they picked them all out. Well, the fact that the Big Five doesn't carry those handguns is evidence of the non-existence of the fact testified to by the witness. And when Mark Heffernan comes in here last week and says that he gave a tennis lesson to Eric Menendez the morning of August the 18th, the morning when they were allegedly at the Big Five buying the non-existent handguns, that is other evidence of the non-existence of the fact testified to by the defendant. And the court's going to tell you that you can consider those kinds of things in evaluating the evidence. The other thing the court will tell you is that discrepancy in the witness's testimony, or between his testimony and someone else's testimony, do not necessarily mean that the witness should be discredited. If we all went to the same movie, let's say, and afterwards we were all asked to describe the movie, everybody would describe it differently, because that's just human nature. So the question really is not was there a discrepancy in the testimony, and this applies to the defendants as well because they're witnesses, but whether those discrepancies have to do with something major or something that's understandable. The other instruction you're going to give, and this is actually my favorite instruction for being the most confusing, and this is how it starts. You are not bound to decide an issue of fact in accordance with the testimony of a number of witnesses, and it goes on. What this really says is don't count the witnesses. The people in this case presented a far fewer witnesses than the defense. And this instruction tells you that you don't just count up the number of witnesses and decide, well, the defense called 40 or 50 witnesses, the prosecution called 20, the defense wins. That's all this particular instruction says, but it takes a long time to get there. That's fine. That brings me to, yeah. And that particular instruction brings me to the next part of my argument. This is part 2. I only have 3 parts left. These are the prosecution witnesses. I'm going to go with you very briefly through each of the witnesses that were testified in the prosecution's case in chief. Christine Nye was the dispatcher from the Beverly Hills Police Department who testified that she received the phone call from Lyle Menendez. We know it's Lyle Menendez now. In the late evening of August the 20th. Avril Crome was the neighbor who lived 2 doors down from the Menendezes, who testified that she heard what she thought were firecracker noises somewhere after 10 o'clock, between 10 and 10:15 is the best that she could put the time. Now later on, the defense brought in Mrs. Lord, who indicated that she was a neighbor who heard these sounds, and she thinks they were at 10 because she remembers looking at her clock. And for purposes of discussion later, in fairness and to benefit the defense, we will fix the time of the killings at 10 p.m., even though Mrs. Crome said she thought it was a little bit later. Officer Michael Butkus was an officer from the Beverly Hills Police Department who arrived at the scene and observed the demeanor of the defendants. Demeanor was how they were acting. He saw them come out of the house. He saw them act grief-stricken that night. Sergeant Kirk West was the gentleman who came in and testified that he and others went into the house and searched the house. He said he saw rifles upstairs in the closet. He saw no smoke. Remember, smoke is something that keeps coming through this trial. The defendants talked about the smoke when they first talked to Sergeant Edmonds and later on. But Kurt West was here to tell you that when he got there, which was about 3 minutes after the 911 call, there was no smoke in the den. That becomes less important now that we know the defendants did the crime. But let me point out to you something. When the prosecution presents any kind of case, we have to prove 2 things. We have to prove a crime occurred, and we have to prove who did it. And when the defense attorneys stood up in opening statement and they said, well, our clients did the crime, that is not evidence. The people cannot rely on the defense attorney's opening statement to prove their case, just like what I'm saying to you right now isn't evidence. So even though it was pretty obvious all through the trial that the defendants weren't going to admit that they did the crime, the prosecution still has to prove that they did the crime. We have the burden of proof, and it's fine that the prosecution has the burden of proof. I think it's essential to our system of justice that prosecutors have to prove what they say they can prove. Otherwise, people should not be convicted. That's the system of justice we have here. It is imperfect, but in my opinion, it's the best system of justice. Prosecutors must prove what they say they can prove. And we have to prove it beyond a reasonable doubt. But we also have to prove not only that they committed the crime, but who committed it. So in our case, when we proved that the defendants did it, we weren't doing it to be overbearing. We weren't doing it to be to waste time. We had to prove that. We had to prove that the defendants were the ones who committed the crime. And Dr. Oziel was one of the essential components of proving that they did it. Because if I had proved to you a murder, but I hadn't proved to you who did the murder, then I haven't carried my burden of proof, independent of anything the defense says. The prosecution's entire case, all these witnesses on this page, have to prove the commission of the crime and who did the crime. So when Sergeant West said, well, there wasn't any smoke in the den, that's so I can later on tell you, well, when the defendant keeps talking about smoke in the room, that proves that he was there at the time of the killings, not later on. Now, you all knew that he was there because his attorney told you that. But in terms of what I have to prove as an attorney, I have to prove he did it, independent of what his attorneys might have said. Sergeant West also said that when he came in the front door that you could hear the television set from the front door. An interesting point in this case. He said that the lights were on inside of the den, and he also indicated that the lights were on in the guest house and the door was open. Now, recently you heard testimony from Marzi Eisenberg that Lyle Menendez told her a day or two after the murders that he was in the guest house and didn't hear anything. And it's the people's offer to you that that was a contingent alibi. That what he told Marzi Eisenberg was one of the things they had planned to say if in fact the police had arrived more speedily than they did. In fact, they didn't arrive at all until the defendant called them, and I'm sure that was sort of a problem for the defendants because then they had to make the phone call. But it's the people's position that that was the contingent alibi, that they went to the guest house, and you'll notice in the photograph, I think it's 397, it was marked later on, that you can see that the guest house is in fact well lit with the door open. Bob Anderson was the gentleman from the shark fishing trip. He indicated that both of the defendants were wearing jackets. He indicated that the family arrived at approximately, and he was very, very general, approximately 4:30 or 4:40, that they left the dock, and he said between 4:30 or 5, and that they returned to the dock between 11:30 and 12 that night. And he described that the defendants were in the front of the boat and their parents weren't with them for most of the trip. Now, the defense interpretation, I'm sure you know, is that they were afraid of their parents. Now, remember the testimony of Lyle Menendez when he said he thought that this boat trip was the parents' way of killing them. That is utterly ridiculous. You saw Mr. Anderson. He indicated there were 2 other people on the boat with him. It's not even reasonable to think that the parents weren't going to kill him there, but it's also not honest on the part of the defendant. A criminalist from the crime lab, Mr. Catalani, came in very briefly, and you probably don't even remember him, and he indicated that there was blood on the sole of Mrs. Menendez's shoe. Well, that seems to indicate that she stepped in blood, and you can draw your own conclusions from that. Sergeant Edmonds testified. Sergeant Edmonds was the gentleman who first talked to the defendants, aside from the officers at the scene. He was the gentleman who was back at the station conducting interviews. And Sergeant Edmonds, we played tape recordings of the statements of both defendants in which both of them were able to get out the story that they had agreed to, which is that they'd gone to the movies, they'd gone to the wine tasting, and then come back to find their deceased parents. Again, it seems that if the defense theory is correct, that these defendants were acting out of fear and fright and that they were almost on automatic pilot like a scared snail, as Dr. Burgess testified, how did they have the state of mind, the presence of mind, to pull it together, to formulate this alibi, to do everything they did after the crime, and then go talk to Sergeant Edmonds, and both of them managed to get through it and say, yeah, this is what happened. And Sergeant Edmonds, with his 32 years of experience, was fooled. Now, the defense is going to argue that that just proves how genuine their grief was. The defense argument is that proves how genuine their acting is. Deputy Van Horn came in. He was the gentleman who brought you the shotgun to show you how the shotgun worked. And he indicated that that particular shotgun, that particular model purchased by the defendants, and Ms. Adams Geyer said the same thing, holds 6 shots, and that in order to have 6 shots in the gun, it normally holds 3, but if you take a plug out of it, it can hold 6. Perry Berman. Now, these are not exactly in order of how the people testified because the computer wouldn't do it the right way. So Perry Berman was the next witness. He was the alibi witness, and when I think the defense is going to characterize Dr. Oziel as being the people's star witness, Dr. Oziel is not the people's star witness. Perry Berman and Amanda Adams Geyer are the people's star witnesses because they establish 2 facts that the defendants cannot escape from. Perry Berman indicated that he left the house on Sunday, August the 20th, at about 10:30 and returned at 1. And at some time during that period of time, he received a phone call from Lyle Menendez on his answer machine. He returned the phone call at approximately 1 p.m., and he talked to Mr. Menendez. Mr. Menendez told Perry Berman that his sons were shopping at the Beverly Center. They seem to shop a lot. They were shopping at the Beverly Center, and Mr. Berman and Mr. Menendez talked about the fact that Mr. Berman wanted Mr. Menendez to help him get a job. He wanted to go into some sort of business dealing tangentially with show business, and Mr. Menendez indicated to him, I'm going on a trip. When I get home, we'll meet. If you were going to kill your sons that night or in the near future, would you make arrangements to meet with one of their friends to help with his future business plans? Wouldn't you say instead, gee, Perry, I'm really sorry, I'd like to help you, but I'm really busy right now, I can't. But what Perry Berman testified to is that Mr. Menendez said, sure, I'm going on a trip, call me when you get back. Karen Farrell testified that she was supposed to go play bridge with the Menendezes either Friday the 18th or Sunday the 20th. What, come over, play bridge and watch us kill our sons, or come over and play bridge and we'll explain to you that our sons have run away and are never coming back? I mean, the conduct of the parents totally belies the story, the lie told by each of these defendants in this case about what happened between August the 15th and August the 20th. Before I continue, I'd like to say this. This is not a case about sexual abuse, and sexual abuse is a very hot topic and has been for probably the last 15 years in criminal law. Sexual abuse happens to people. I'm not going to stand here and say that children are not abused. Children are abused a lot in our society, and it is a horrible, horrible crime when a child is abused, especially by a parent, because there are issues relating to parental abuse that are separate and apart from being abused by a stranger. You know, a stranger you can hate. It's hard to hate your parents. And yet, in this particular case, if you believe in the sexual abuse, that doesn't mean that the defendants are not guilty of murder, because they are 2 separate things. The sexual abuse in this case, whether you believe it or not, was disavowed by both defendants as to why they killed their parents. And it's the people's position that the sexual abuse is here to make the parents look so bad that you don't care that they're dead. That's why the sexual abuse is brought up, because each defendant said, in fact, at the beginning of cross-examination, I said to Lyle Menendez, did you kill your parents because of what they'd done to you before? No. The sexual abuse, the defense will argue, is to explain why they were so afraid and why the events of August 15th through August the 20th are so compelling. But the real thing is the sexual abuse is to portray these people as monsters so that you will not care that they were dead. The same way if a dope dealer, let's say a horrible dope dealer who's selling drugs to children around a schoolhouse, is murdered, do you really care as much if that person gets killed as if it's an innocent bystander, someone at an ATM machine gets killed? I mean, those are very different things. But in the law, the dope dealer, the person at the ATM machine, the President of the United States, they all have the same right to live. And in this particular case, if Mr. Menendez was a sexual deviant, pervert, child molester, And as a prosecutor, I have very strong feelings about child molesters. If he was a child molester, we would have tried him for it. The district attorney's office has lots of resources available to try child molesters, lots of people who are specially trained in dealing with child molesters. And as a matter of fact, the district attorney's office would have been more than happy to make those allegations true. You see, there's a difference between being an alleged child molester and a convicted child molester. There are people in society right now who are being said to be alleged child molesters, but until that person's brought into court and given the opportunity to test the charges, to present a defense, to cross-examine the witnesses, they are not a convicted child molester until a jury like you says so. We don't execute child molesters in California, and some of you might think that we should. I think there's certain child molesters that I might think that we should execute. But the state doesn't execute child molesters. The state only executes certain kinds of murderers. And until the legislature or the voters through a referendum change the law to execute child molesters, we can't execute them. And these defendants can't execute them either. So keep in mind that although you might believe that Mr. Menendez was a child molester, he was only an alleged child molester. And as a child molester, he had the same rights to present a defense as his son. And he had the right to spend his money to defend himself. And he had the right to hire an attorney or two to defend himself. And he had that right, but that right was taken away from him. So keep in mind that in our country, we have a country of laws, and vigilantism is something that we cannot tolerate. Because then what happens when you say, what if you decide your neighbor's a child molester? And you go kill your neighbor, and no one's ever proved your neighbor's a child molester. And where does it stop? That you get to start killing all the dope dealers in the neighborhood? We have a system of laws that protect the guilty as well as the not guilty, that protect the petty thief as well as the murderer, and they're all the same kinds of laws. So keep in mind that Mr. Menendez was never a convicted child molester, and that the state would have prosecuted him if the defendants had so desired, but they didn't. Continuing on now with Mr. Berman. Mr. Berman indicated that he called Lyle Menendez back on the telephone between 4 and 5 in the afternoon. Perry Berman did not testify as Lyle Menendez did. Perry Berman did not testify that Mr. Menendez had told him, when he talked to Mr. Menendez earlier, that Lyle and Eric could not go out that night. He didn't testify to that. He testified that Lyle Menendez told him during the phone call between 4 and 5 that Lyle and Eric were going to see Batman and that they would meet Perry at the Taste of LA at about 9:30. Obviously, they thought they could get the murder accomplished earlier than they actually did. Perry Berman testified he left the Taste of LA at approximately 10 o'clock, that Lyle called him after 11, and we know from the phone records that Lyle called him at 11:07. And Lyle indicated to him that he'd gotten to the Taste of LA at 10:15. This covers him because it takes more than 15 minutes to drive from Beverly Hills to Santa Monica, and so Lyle Menendez is basically saying, I got here at 10:15, I couldn't have been home at 10 when the murders occurred because I was en route. This, of course, is a lie, but this is what he tells Perry Berman. And then, if you recall, he called back a second time and tried to get Perry Berman to meet him at the house, and Perry said, no, I don't want to disturb your parents. Remember, Mr. Menendez is going to help him get a job. I don't want to disturb your parents. I'll meet you at the Cheesecake Factory. Donovan Goudreau testified that he was not the one who bought the shotguns. Now, it was very clear from the defense attorney's opening statements that the defendants were going to say that they had purchased the shotguns, which they have to do because we've got the records proving they did. So they can't exactly take the stand and say, well, we didn't buy those shotguns. So they have to admit that they bought the shotguns. But Donovan Goudreau was called to testify because the people have to prove the elements of the crime of murder, premeditated murder, and he said he didn't buy the shotguns. He also indicated that when he moved out of the room at Princeton, his wallet was gone, and that Lyle admired Chuck's Spring Street Cafe, that Lyle didn't have a lot of cash normally. And the other thing that he said that was interesting is that after the homicides, after the murders, Lyle Menendez didn't contact him. Now, we know from this conversation of September the 17th that The detectives told Lyle Menendez in Princeton when he was staying with his family, "Oh, your friend Donovan Goudreau wants us to send word to you. He's working at Boxer's restaurant." Now, Lyle Menendez made a great show of the fact that Donovan was his dearest friend, and he was crushed when Donovan had to leave the room, and yet his parents are dead. He's doing exactly what he wants. He's buying the watch, driving the Porsche. He hooks back up with Jamie Bozanich, and he doesn't call his dear, beloved friend Donovan Goudreau. If, in fact, Donovan was such a good friend, why didn't he? Especially now that his father was out of the way. Mr. Wenskowski, Richie Wenskowski, he was the gentleman with the rather thick New Jersey accent who testified that he worked as a bodyguard for Lyle Menendez, that Lyle Menendez indicated that the mob or the cartel had killed his parents. He guarded him from either the 28th or 29th of August until September the 6th. Now, Mr. Slotkin testified recently that he had a conference with the two defendants dealing with their lost state. They were lost souls, and oh, by the way, they wanted some money advice. And that this conversation took place within the first 2 weeks of his initial meeting with them on either August the 21st or August the 22nd. That is very hard to do, because what happened is the defendants both went back east about the 25th or 26th of August. Lyle Menendez flew home for 1 day by himself to erase the computer, immediately flew back on the 31st of August. And we know from records that he was in Princeton through a period of time, at least to the 8th of September. And we know from Mr. Wenskowski, he guarded him through September the 6th. On the September the 8th, Lyle Menendez is buying condominiums in Princeton, New Jersey, and signing documents. So when was it that Mr. Slotkin saw Lyle and Eric Menendez? I submit to you that he saw them that first week before their parents' funeral, because Lyle Menendez was on the East Coast continuously for 2 weeks, except for the 1 day when he flew home. Mr. Wenskowski also indicated that Lyle Menendez spent a lot of money, that he bought clothes, a car, townhomes, and he wanted to buy a bulletproof limousine. He also asked Mr. Wenskowski if you could get ballistics off a shotgun shell. I submit to you that when Lyle Menendez went back in the room with his brother to pick up the shotgun shells, he wasn't just worried about fingerprints. He was worried about ballistics as well. He was worried, and remember Deputy Van Horn talked about the fact that you can match a certain shotgun shell as having come from a particular shotgun. He also indicated that Lyle Menendez called him shortly before his arrest in March of 1990, and Lyle Menendez had flown home with Glenn Stevens and another friend. He called Mr. Wenskowski and said, "Hey, I understand the Beverly Hills Police were at my restaurant," which was at that time changed from Chuck Springs Street Cafe to Mr. Buffalo's. And Mr. Wenskowski says, "Yeah, they were here. I don't know what they wanted." We know from Lyle Menendez's testimony that during that particular trip back to Los Angeles, he went looking for the guns again. Lyle Menendez knew that the police were on his trail, and he went to look for the guns again after he talked to Mr. Wenskowski and found out that the police had been back at the restaurant. The next witness who testified was Amanda Adams Geyer. Miss Geyer is the lady who sold the shotguns to the defendants. And again, along with Mr. Berman, she is one of the key prosecution witnesses. Now, what she had to say was pretty bland. "Yeah, I was there. I filled out some forms. I can't identify them." But what's so significant is that they bought the shotguns 2 days before they slayed their parents. She indicated that when this one person came in, that he had no hesitation. He said, "I want 2 of those." And she indicated that the transaction was fairly brief. But we know things from that transaction which are very damaging to the defendants. We know that they used false identification. We know they used a false address. We know they used a false place of birth. And we know that they drove 2 hours to San Diego in order to buy those shotguns. Now, Lyle Menendez's explanation was, "Well, I just was driving and I'd been to La Jolla before and we just ended up there." What happened is they went to a local gun store, and it probably was the Big Five in Santa Monica, and discovered that in order to buy these guns, you have to fill out a form. The form that you saw in here, it's in evidence now. You have to fill out the form, and once you fill out the form, people are going to know who you are. So rather than fill out a form within 5 or 10 miles of home, you've got to go out of town to fill out that form. And so what happened is they had to leave town, and you know what? It almost worked. If you remember the testimony of Detective Zoller and the testimony of Judalyn Smith, it wasn't until after she went to the police that the police knew to go to San Diego to look for the guns. And as difficult a person as Ms. Smith might be, but for her, they wouldn't have known where to go to get the guns. So Dr. Burgess talked a lot about the fact that this was a disorganized crime scene and, that a good murderer would have done it better. But that's not how people behave. And these defendants almost got away with this crime. So keep that in mind when you evaluate Dr. Burgess's testimony. Glenn Stevens was the friend of Lyle Menendez, and I'd like to say something about Mr. Stevens, Mr. Grant Walker, and people like Jamie Pizarczyk. The defense impeached Mr. Stevens with the fact that he exaggerated his resume and he stole money out of a till, and that's something he came forward with. Yeah, I stole money out of the till from the restaurant. Is it so hard to understand that people, that friends or relatives of these defendants might be appalled by what they did? Jamie Pizarczyk, when she found out that Lyle Menendez was in fact responsible for murdering his parents, went out and got a new boyfriend. Well, is killing your parents a really attractive quality in a future mate? It seems to me that people here have their morality and their ethics just jumbled. I mean, slaughtering your parents is a really horrible thing. And when Glenn Stevens said, friendship transcends a lot, it doesn't transcend murder, that should be the correct way to view this particular crime. It is a horrible thing to do to someone. And your friends might forgive you if you drive without a driver's license or cheat on your spouse or do some other thing that people do. But I don't think anyone's friends or relatives need to forgive them or understand or cover for someone when you murder your parents. And these people, were sucked in by Lyle Menendez, and he portrayed himself as this grieving son. He portrayed himself as potentially being victimized by the mob himself. I mean, he hired a bodyguard, for Christ's sakes. He wanted people to believe that he was next. He wanted people, he not only said, I don't know who did it, but he diverted attention specifically to the mob or the cartel. And then he began to think, ooh, that's not such a hot idea because maybe the mob will come after me because I've slandered them or I've said that they did something that they didn't do. So he thought better of that position and began to retreat from it. But when Mr. Stevens came and testified in this court, he was cooperating with the police early on because he didn't think that this was a very good thing. He didn't think that Lyle Menendez killing his parents was acceptable. And the defense wants you to believe that he's a horrible person because he snitched off his friend. Well, that just sort of is looking at things the wrong way, because if you had a friend that murdered their parents or their spouse, the appropriate human response is to feel revulsion for that. And if we don't feel revulsion at that kind of violence, then something's wrong. He indicated, Mr. Stevens, that Lyle Menendez told him at the memorial service in Princeton that he'd waited a long time for the position he'd been in. And that is similar to what Marzi Eisenberg testified to when Lyle Menendez said, no, Marzi, you don't understand. These are my father's shoes. Lyle Menendez, in a way, wanted to be like his father, travel in limousines, be a big businessman, wheel and deal like his father. He also indicated, Glenn Stevens did, that Lyle had gone home to look at the computer, that there were 3 things on the computer he looked for, Menendez, list, and will. That directly tracks Mr. Whitkin's testimony. And if you didn't like Mr. Stevens because you thought that he shouldn't have lied on his resume, how about Mr. Whitkin? Mr. Whitkin came in here and talked to you, and Mr. Whitkin there was no reason for that man to lie. He was very believable. So much of what Glenn Stevens has to say is corroborated by the testimony of other witnesses. Mr. Gross came in, and Mr. Gross indicated that the handwriting on the shotgun purchase records was probably, he couldn't say definitely, Eric Menendez's. Again, it might have seemed silly to you that we called him, but we had to prove it independently of what the defense attorney said. Mr. Whitkin indicated that the computer was erased on August the 31st, that he was asked to look for Lyle, Eric, Will, and Menendez. And he indicated something interesting. He said that it made his spine crawl when Lyle asked him to make it look like he hadn't been there. And Mr. Whitkin testified that at the time that Lyle Menendez made that request of him, he didn't know there'd been a murder in the house because he doesn't read the Metro section. And so I think that's an interesting observation from someone who was actually there. You see, we come into court and we all get dressed up and everybody's very civilized, and the courtroom's paneled and carpeted, and there's the judge wears a certain kind of robe which judges for centuries have worn, and everything is very civilized. And we show you pictures because we're not going to bring in blood and gore. But remember that what happened on the night of August the 20th was very different from what happens in a courtroom. And this is a two-dimensional picture of blood and gore. You can't even smell what this must have smelled like either. You can't sense what this must have felt like. Mr. Witkin was not there during this period of time, but Mr. Witkin was there on August the 31st, and he said that Lyle Menendez made his spine crawl, and he didn't even know there'd been a murder in the house. Mary Ellen Mahar was the lady from Slavik's Jewelry who indicated that approximately $15,000 worth of Rolex watches and money clips were purchased on August 24th. Now, I, like many women, like to shop to relieve stress or shop for entertainment or shop just to shop. But shopping to get over killing your parents seems to be taking shopping a bit far. On August the 24th, Lyle Menendez went out and bought a watch, and Ms. Mahar testified that he called up somebody named Carlos, or I'm not sure she said Carlos, so don't quote me. She called up and he was talking about the propriety or the way it would look to wear the Rolex to the funeral. Well, we know he did wear the Rolex to the funeral in Princeton. So even though it was something his father didn't really approve of, he went ahead and he bought it and he wore it, and it was a version of telling his father where to go. You also heard from Dr. Golden, who was the coroner's representative, and I'll go through what he said a little later. You heard from Dr. Oziel. Now, Dr. Oziel, I think the defense proved beyond any possible doubt that Dr. Oziel was a philanderer. He cheated on his wife. They proved that, absolutely. They did not prove that he can't work a tape recorder. And ultimately, all the bad things said about Dr. Oziel, all the horrible things, I mean, this was a trial. The defense really tried Dr. Oziel for his crimes and misdemeanors. And in the end, when you hear the December 11th tape, who cares? Because how hard does it, I mean, what kind of person do you have to be to run a tape recorder? Dr. Oziel testified to prove identity. He was here to prove that these defendants and not somebody else did the crime. And the defense spent a great deal of time trying to discredit Dr. Oziel, and part of that was done because they had the ammunition to do it. There have been presidents of the United States who've had girlfriends, and they were not crucified as badly as Dr. Oziel. But Dr. Oziel sat there for days, and he took it. And they brought in Judalon Smith, and whatever you think of her, she was obviously his girlfriend at one point. And that was all done so you would lose sight of the evidence. The defense doesn't want you to remember this. They want you to think about that horrible Dr. Oziel. They want you to think about Glenn Stevens cheating on his resume. They want you to think about Judalon Smith as the woman scorned. They want you to think about Dr. Burgess and her theory about snails. They want you to think about anything but this picture. Now, I've only put up one exhibit here because this is not a complicated case. This is a very straightforward case. We only called this many witnesses. This is not a hard case at all. This is what happened. These two people were sitting there watching television, and they got slaughtered by their sons. We proved that they bought the guns on August the 18th. We proved that Perry Berman was called to set up an alibi. There are other things that I'm going to discuss later on in my argument to prove that the defendants lied to you in this courtroom from the witness stand, but we know they lied every chance they got. This one picture is all you need. This and the other evidence that people presented proves that this is a premeditated first-degree murder. It was done through conspiracy. It was done by lying in wait. So all this other stuff, Dr. Oziel, I mean, if I were a defense attorney and the prosecution called Dr. Oziel, I'd be jumping up and down because you've got Judalon Smith, you've got Cindy McPhee, you've got Pamela Bozanich to come in and say bad things about him. But in the end, listen to Lyle Menendez's words on the December 11th tape, and it doesn't matter who Dr. Oziel was sleeping with. Dr. Lulo and Brad Brunon came in. Dr. Lulo was the psychologist, and I would say that we've had enough psychologists in this case to sink a ship. But Dr. Lulo came in and said, I talked to Dr. Oziel on Halloween. I remember it was Halloween. I told him to make tapes. I told him to make notes, not tapes. Told him to make notes, put them in a safe place. Tell your client, patient, that you've done this. Mr. Brunon, who was his attorney, came in and gave him and said that he'd given him essentially the same advice. Detective Zoller was called and several times during the trial, because as the investigator he has little bits and pieces here and there. But some of the things he told you were that the defendants wanted to get into the room on August the 21st. Remember, they came at 5:30 and they wanted to get back into the crime scene. Now, it's interesting to note that when Sergeant Edmonds was talking to Lyle Menendez, he explains, we don't want you going into the crime scene because you might disturb some evidence. And Lyle Menendez is thinking, oh gosh, what if I left something? So he goes back and says, hey, we need to get tennis equipment in that room. And if you look at the photographs of the room, you'll see there's tennis equipment everywhere. But it's Sergeant Edmonds who probably tipped him off that he might want to go back. We also know from Detective Zoller and from Lyle Menendez himself that he went back and went through the car, and in front of the police, he took evidence out of the car which might have incriminated him. That is pretty cool. I mean, to be able to kill your parents, go talk to the police, go back to the scene of the crime in view of a police officer, go through your car, take some shells, put them in your pocket, walk off. That takes an amazing amount of cool. And if in fact the defense theory is correct, that he was acting out of fear and he was just all upset, that doesn't go along with this idea that he went back to the scene of the crime. You know that statement that the killer or the criminal always returns to the scene of the crime? Well, he comes back and he removes evidence in front of the police. I would think that most people would just cross their fingers and hope that the police didn't look in the car. Detective Zoller also indicated he was here to talk about the statement of September 17th, and there's only one portion of it which I'd like to highlight, and I'll do it now. In the September 17th statement, Lyle Menendez talks about the camcorder, and that is important in light of the testimony of Mr. Anderson. Mr. Anderson indicated that Jose Menendez was going to have a talk with him. Jose was in Kalamazoo with his son Eric. He wanted to talk to Lyle about the camcorder that had recently been purchased. Now here's the statement from September 17th. Zoller says, now one statement I heard, and I don't know who it was from, you had gone out, bought like a video recorder, a camera. Lyle Menendez says, yeah. And your dad said, gee, that's nice that he could buy something like that. I wonder how he could pay for it. And Lyle Menendez says, yeah, he said that. But, you know, Mr. Detective Zoller says, did he end up paying for it? Lyle says, he ended up paying for it, sure. I mean, you know, it's one of those things where if I knew we needed it and I knew that he thought it was a good idea, he wouldn't buy it himself ever. But I'd buy it. And then, you know, we just discuss it and he'd buy it and he'd pay for it. Or if it came down to it, you know, I could pay for it. Detective Zoller says, uh-huh. Lyle Menendez says, my father forever, unintelligible, but trying to teach us the value of money, and unintelligible, but there were lots of fights. The motive for the murders is that these defendants were starting to get into a great deal of trouble with their parents. Eric Menendez testified that his father had disinherited him and was going to disown him in the spring of 1989. We know that shortly before their murders that Mr. Menendez wanted to talk to his son about this camcorder. Lyle Menendez admits in the September 17th statement that there were lots of fights. The father was trying to teach him the value of money. When Lyle Menendez goes back to California on August the 31st to erase the will, it's not because he thinks his cousin Carlos is going to do something fishy with the will. It's because the family had already found the two wills that had been executed in 1980 where both of the defendants would inherit. And any subsequent wills would never help this particular defendant. Detective Zoller also indicated that he recovered the information about Howard Witkin in early December of '89. That's how he found Howard Witkin. And also testified about a service of a search warrant on Dr. Oziel, where some tapes were recovered. I'd like to reemphasize again that if you believe that Mr. Menendez was a child molester, that does not mean that these defendants committed voluntary manslaughter. In order for them to be guilty of voluntary manslaughter, they have to actually have killed in the heat of passion or in the unreasonable belief in the need of self-defense. Mr. Menendez, if he were a child molester, had a right to have an attorney. He had the right to a jury trial. He had the right to a fair and impartial jury. He had the right to confront and cross-examine the witnesses against him, which means he had the right to sit in the courtroom, look at his sons, and have them questioned by his attorneys to test the validity of their allegations. He had the right to testify if he wanted to. He had the right to take the stand and say, I didn't do those things, and let me tell you why, or I was out of town, or to present an alibi if he so desired. He had the right to present a full defense and call his own expert witnesses. He could have paraded 3 or 4 or 5 or 6 psychologists in here to explain him and his actions or his son. And he had the right to spend his own money doing it. So I'd like to reemphasize that just because the defense has said that he is a child molester, he's not a convicted child molester. And we in California do not execute child molesters. Now, the next part of my argument deals with the defense case. All right, the first group of witnesses, and I'm not going to talk about each one of these except some of them generically. Family, friends. The two, Tracy Baker was the young woman who came in and said that Kitty Menendez was nasty to her and pushed her onto the sofa because she admitted that she'd been sleeping with Lyle. Sleeping was a euphemism for having sex with Lyle Menendez in Kitty Menendez's house. And yet this horrifying, horrible, awful experience did not prevent her from calling up and asking for concert tickets later on from Mr. Menendez. The other witness called by the defense was Edward Fenno, and Mr. Fenno tried to paint a particular picture of the victims, but in doing so, he also indicated that the defendants lied a lot to their parents, and that they gave detailed lies, not general lies, but detailed lies. Well, in this particular courtroom, you heard very detailed accounts given by both Lyle Menendez and his brother Eric. But Mr. Fenno indicates that before they were even charged with murder, before they murdered their parents, they gave detailed lies, and they knew how to do it. The other thing is that Mr. Fenno backed away from a statement he had made, and I impeached him with a prior inconsistent statement from Detective Zoller at the end of the trial. Mr. Fenno said originally that Jose Menendez was very excited about Eric going to Berkeley. Well, that's really significant because if you want to have sex with your son, you want him in the same town. And so that particular statement that Mr. Menendez was excited about Eric going to Berkeley is circumstantial evidence that Eric Menendez was not being sexually abused by his father. Another interesting thing that came out late in the trial is Marzi Eisenberg testified that when Mr. Menendez and Eric Menendez first came to California, when Mr. Menendez was first working at Live, he was out here for several months where Mrs. Menendez was not permanently residing here. She was flying back and forth. And on many occasions, Marzi Eisenberg had to pick Eric Menendez up in high school and take him somewhere. Eric Menendez testified that for the first 3.5 months in California, there was no sex with his father. Well, it's interesting to note that if the mother was not even in town, if Mr. Menendez was having sex with the son, wouldn't the opportune time to be is when they're alone in this condominium at the Oakwood Apartments? Another piece of circumstantial evidence that this abuse is totally fabricated. Relatives, Marta Cano. Marta Cano, interestingly indicated, and I realize that this is a very long process and that it's hard to sit here and listen to this, but I'm going to try to keep my comments. Usually I would argue 2 days on a case like this, and I'm trying to keep my comments to way under that, so please bear with me. Marta Cano was the aunt of the defendants who flew into town, immediately went to Live Entertainment, and began to look for Jose Menendez's assets. That is an interesting reaction to grief. She indicated she spent Tuesday, Wednesday, and Thursday after she got here looking for his assets. She also indicated, in a rare moment of candor, that she would lie even for me. I asked her about lying, and she said, well, heck, I'd do the same for you. She was talking about telling a lie to Jose Menendez about an accident that Kitty Menendez had had. Mrs. Cano was fairly well impeached, but again, her motivation may be, I can't do anything for my brother, I'm going to help his sons. She also indicates that the defendants told her that they didn't think they were in the will, but from the testimony of Carlos Baralt, we know that the will was found early in the week, and her conversation with the defendants wasn't until Wednesday or Thursday, and more likely on Thursday. And she was impeached with a prior statement about the fact that it had been on Thursday and not Wednesday, which is interesting because if the watches are bought in the afternoon of Thursday the 24th, what money did Lyle Menendez think he was using to pay for those watches? You see, the will had been found before they went watch shopping, He knew that everything was okay. He knew that the will left things to he and his brother. Then he meets with Marta Cano later that night and pretends on the night of the 24th, oh, well, you know, we're not in the will. He knew he was in the will. He just didn't want to look greedy to his relatives. Also, interestingly, Marta Cano was not present at live entertainment when Roger Smith had the talk with the defendants about the $5 million policy. Now, there's been a lot of dispute about the $5 million policy. Much to the defendant's chagrin, Mart Slotkin came in here last week and indicated that these defendants talked to him in this 2-week period, which couldn't have been during that 2 weeks, it was during the first week. These defendants talked to him about this $4 or $5 million that they were going to get from the company. Well, we know that's not the sale of the house. We know that's not stock options. It was an insurance policy that they thought they were going to get. So Marta Cano wasn't even in on that discussion. And remember in the discussion, Roger Smith says that Eric Menendez said, well, what about the insurance policy in favor of the company? And that was the $15 million policy. Eric Menendez knew full well and good that there was a lot of money at stake. And unlike the whimpering, whining, crying creature he wants you to think he is, at the meeting with Roger Smith, he was more than willing to stand up and say, what about the policy in favor of the company? And these defendants didn't do this crime for anything but fear. That's what they want you to believe. Carlos Baralt and his his wife, Terry Baralt, came in and probably gave the most accurate portrayal of the Menendez parents that was given in this case. They said bad things about them and good things about them. And I think that their portrayal of the family and the Menendez parents is probably the closest to accurate that you got in this case. Mr. Baralt indicated that the will was found on Tuesday. That would have been the 22nd of August. And that was the will, which is in evidence, and you'll see the two wills. They're pretty standard. Mr. Menendez dies, it goes to Mrs. Menendez. Mrs. Menendez dies, it goes to Mr. Menendez. If they both die, it goes to the sons. It's a fairly standard way of leaving your estate. Pat Anderson indicated that she was present in Kalamazoo when Eric talked back to his father on the tennis court, something that Brian Anderson testified to himself. Diane Vandermolen indicated that she stayed at this horrible, horrible home a lot. And I'd like to ask you, think to yourself, if this was such a horrible place to be, why did she keep going back? Why did she live there for summer after year after year? She also indicated that Lyle Menendez had made what we call a fresh complaint about sexual molestation to her. But interestingly, this fresh complaint was not made to her until the second or third interview with the defense attorneys and until after the third visit with Lyle Menendez at the county jail. And you'll see the slips that show that she went to visit him in the county jail. It's very suspicious that this particular fact was not even brought forth until after she'd been interviewed by the defense investigators 2 or 3 times. Joan Vandermolen was the sister to come in who said that Kitty Menendez, part of why she was here is to say that Kitty Menendez was very secretive, that she hid things from her family. But we know that Mrs. Menendez talked to her brother Brian because Brian was the one she was closest to. We also know from Joan Vandermolen that somewhat like a vulture, she went into her sister's closet and took her clothes because after all they were the same size. Then we have the expert witnesses. I could spend 2 days talking to you about the expert witnesses. Dr. Bruyere was the generic child abuse person. He was here to tell you how you should look at the evidence. Dr. Burgess was here. She was here to use crime scene analysis, which detectives used in order to figure out who did a crime. She was here to use that in a bastardized form to get you to understand the defendant's state of mind. Those particular analysis that are done by the FBI are done to help investigators like Detective Zoller look at a crime scene and try to figure out who would have done it. It was not formulated for people like Dr. Burgess to come in here as a hired gun and to tell you that from the crime scene you can tell certain things about what happened. She described this as a disorganized crime scene, and yet by her own definition it was a mixed crime scene because there were certain features of it that showed pre-planning. But the thing that she wouldn't get off of and the thing that she was going to stick to her guns no matter what was that because the defendants got caught, this was a disorganized crime scene. Where there are lots of people in county jail and in state prison who plan their murders, but because of things that they couldn't foresee or because of things that happened either before or after the crime, they got caught. Just because you get caught didn't mean that you didn't plan it. And that is such a simple, simple thing, and yet she wouldn't admit it. And the reason she wouldn't admit it is because she's paid to be a witness for the defense. She is paid to come in here and say what she said. And she was very sweet and nice about not budging from her position. But the fact that she wouldn't give 1 inch shows you how incredibly biased she was. And to say that because the defendants didn't plan out the crime scene so as not to get caught shows that they didn't plan at all is ridiculous. And I use the example of a wedding, where you plan a wedding and you plan it and you plan it and you go get the license, you hire the caterer, you hire the minister, you hire all these people, and the day of the wedding comes and it just is a disaster. Things don't go the way it's planned. I had a wedding like that. You plan it, and then everything just goes wrong. It doesn't mean you didn't want to get married. It doesn't mean you didn't plan it. It means that things just happened. And if it starts to rain on an outdoor wedding and you didn't think it was going to rain because it never rains in that month, but it rains, what do? Well, that's poor planning. But you still intended to get married. You premeditatedly went out and you got the ring and you got the license and you had the caterer. It's just that things happened that you didn't plan for. Well, in this particular case, think about the fact that these defendants almost got away with this crime. But for Julianne Smith, and I hate to give her that much credit, but I think that she probably deserves it, but for her going to the police to get her boyfriend in trouble, and oh, by the way, there's this murder I know about, but he's a rapist and he's a horrible man and I want you to arrest him, but for her going to the police, it's doubtful they'd be here. So Dr. Burgess may go on and on about this imperfect crime scene in her ivory tower analysis, but in real life, they were at liberty for 7 months before they were arrested. Dr. Hart talked about psychological abuse. Where does bad parenting turn into psychological abuse? I think that's an interesting question. Were they psychologically abused? Well, if you take everything that has been given to you and you look at it in a vacuum, because this is a vacuum. This courtroom is a vacuum. It's not real life. You didn't live in their house. You didn't see the murder. Yeah, you could say that these particular acts would constitute psychological abuse if you exaggerated them, if you blow them out of proportion. And yet, psychological abuse cannot justify murder. It just can't. Now, you may not think you like the Menendez parents. You may think they were bad parents. It does not justify murder. We don't execute people in the state for being bad parents. If we did, there'd be a lot of people dead. Dr. Connie came in here, and Dr. Connie was here twice. He was here once to talk about Lyle Menendez, and he was here once to talk about the December 11th tape. He was here to explain it away because it's an extremely damaging piece of evidence. And so he came back specifically to talk about that tape. Dr. Conti was very clever, and Dr. Conti knows about a lot about child abuse and child neglect. But think about your impressions of Dr. Conti. Think about how you felt about what he was saying. And no matter what was thrown at him, there was not one question I could give him that he didn't have some psychobabble answer for. And that's what he's paid to do. And at one point he said, I wouldn't put my reputation on the line for this case. And I'm just thinking to myself, Dr. Conti, the way you've done in cross-examination, you're going to be in demand all over this country. This is seed money for future venture capital for Dr. Conti, because now everybody who looks like they have a hopeless defense and they can't make it, call up Dr. Conti, get him to come in. In the face of overwhelming evidence of premeditation, he can stick to his guns and he can answer the questions. He doesn't crumble in light of the obvious. So think about Dr. Conti and think about the questions I asked him and the evidence I threw at him, and he was very good at throwing it back. But just because somebody is good at throwing it back doesn't mean it's correct. And then we had Dr. English. He was the gentleman who came in and said that he'd done an examination of the defendants and found no indication of child sexual abuse. And that was all he had to say. These particular doctors here, I'm not going to say Dr. English is one because he's not a psychologist. But notice, first of all, Hart, Conti, and Burgess are all from out of state. They couldn't find anybody in Southern California who knows something about child abuse. I mean, there have been child abuse cases in Southern California in the last 15 years. Dr. Breer, of course, the only local guy, never examined the defendants. He was just here so that you would view the evidence in a certain way. But these three people, and Dr. Burgess especially, these are spin doctors. These are people who are here to put a spin on things to make it look different from what it really is. They're here to tell you how to think. And they have been paid a lot of money to tell you how to think. Now, they've been paid more than $5 a day, but they haven't been sitting in this courtroom like you have watching the evidence. They come in, they take the stand. I'm an expert, I have a PhD. A PhD is a doctor of philosophy, ladies and gentlemen. A PhD is not a medical doctor, they're doctors of philosophy. And they come in here and they say, well, I went to school a lot and I write lots of papers and I get quoted a lot and I quote my friends here and we all quote each other and this is what we think this all means. Well, you don't need these people to tell you how to think. You've been here and spent more time on this case than any of these experts have. You've seen the evidence tested in this courtroom. You've seen cross-examination. You don't need these people to tell you how to view the evidence. Now, the defense is going to make a big deal about the fact that the people didn't call any expert witnesses. Why would you call an expert witness in this case when these people did what they did on the witness stand? Why would you dignify these people's existence as experts by saying, yeah, we think these experts really had something to say, and so we're going to bring our own experts? I'm sure that there are experts on either side, as you well know. But these people that came in here, leaving aside Dr. English, came in here as hired guns for the defendants and nothing more. And they used their years of research and their PhDs and everything else to try to persuade you that you, as common citizens, can't understand the evidence. And that's what they were here for. And for us to call an expert to say, well, this is what it all means, is sort of an insult. Because you've been sitting here watching the evidence. You know what it looks like. You don't need these people who've spent most of their time in academia, most of their time writing papers. You don't need these people to tell you how to think. Right. I'm going to finish these witnesses before lunch. Very briefly, the anti-Ozil witnesses, I think that's a fairly good way of classifying these three people. They were here to say bad things about Dr. Ozil. None of them could prove to you that he doesn't know how to work a tape recorder. Then we have what I call teachers' coaches, and I think that there were enough teachers and coaches here to choke a horse. Mr. Mosner was here. He was a soccer coach. Mr. Klaus was a tennis coach. Mr. Curtin was a tennis coach. Ms. Geisler worked at the country club in 80 and 81 when Mrs. Menendez would throw her children on the mercy of the country club and drive off for the day. Sandy Sharp was, the thing that she said that really struck me as being incredibly catty is that Mrs. Menendez always needed a bleach job. I mean, the woman is dead. I mean, that's what she said. She needed a bleach job. Alicia Hertz came in and she said that she was a friend of the family and also taught them at school. And she said that she saw Mrs. Menendez in August of 1989 and that she was acting unusually. She also indicated that Mrs. Menendez was going to Quito, Peru, and she found that very unusual. Well, it turns out that Mrs. Menendez has relatives in Quito, Ecuador, and so that whole thing is a big non-issue. Mr. Wadlington came in, and the one thing that I think you should recall about his testimony is that he said Lyle Menendez told him he always wanted to open a restaurant. Well, we know that in late 89 or early 90, Lyle Menendez bought a restaurant with his dead father's money. The neighbors I've already discussed, they put, and as I said, for purposes of our discussion, we're going to assume that the killings occurred at about 10 o'clock at night because that gives the benefit of the doubt to the defendants. But the interesting thing about the neighbors is the neighbors heard these noises, and I believe Mrs. Lord either lives on another street or way down the street, and they heard these noises. And yet Mr. Slotkin was brought in to talk about the fact that you can't hear noises within the house. Lyle Menendez testified that on one of the nights he was inside the guest house and he heard screaming and yelling coming from the main house. And yet, so do these people establish, these neighbors show that you can hear noise outside the house, and Mr. Slotkin is supposed to say you can't hear noise inside the house? Or, I mean, it seems to be a conflict in the defense testimony. If you can hear the noise from the shotguns, but you can't hear the noise from the shotguns. I mean, so if you contrast these neighbors with Mr. Slotkin, one of the reasons he was here is to say the maid wouldn't have been able to hear anything. And yet Lyle Menendez said he could hear screaming when he was inside the guest house, and his mother and Eric were inside the main house. Mr. Lowe. Well, Mr. Lowe, remember, he was the man who took Mamie Van Doren to the hotel, and he's not here for publicity, and he testified to the vicious, awful pinching incident. If you look at what happened to these defendants during the course of their life, it's the kind of stuff that would make you mad. Both the defendants were very careful to say, I wasn't angry, I wasn't angry, I wasn't angry. But when Skippy Lowe comes in and he talks about the pinching incident, if I were an adult sitting at a dinner table all dressed up and my father pinched me, I'd be darn mad at him. But I think Mr. Lowe also wins the award in this trial for the most self-interested witness, and I don't think his testimony meant much, except it was somewhat amusing. Mary Dominguez indicated she found pornography inside of the house. We know the house had been rented on several occasions by several people. She's the only witness to testify to this particular pornography, aside from the defendants, whose credibility is almost nil. Mr. Goudreau was here to testify for the defense as to a statement he says, well, a statement the defendant says he told him in a restaurant in Princeton in the spring of 1989. But Mr. Goudreau also was very confused about the source of his information. He indicated he didn't hear that from Lyle Menendez, but had been in contact with a reporter and had talked to people about allegations of child abuse. Mr. Lopez was the gentleman who was the investigator who went to the Big Five after the bomb was dropped during Eric Menendez's cross-examination. Eric Menendez, you can't have bought a handgun, or you couldn't have tried to buy a handgun at Big Five, because if you had, you couldn't have bought one because they didn't have them. So Mr. Lopez was brought in to try to fix it. You know the old saying, if you can't fix it, feature it? So instead of waiting for us to put on evidence to show that they didn't carry it, Mr. Lopez came in and he had all the pictures and everything. But the one thing that was notable about Mr. Lopez, he was never asked by the defense to find the clerk that the defendants had the conversation with on August the 18th. Allegedly at the Big Five in Santa Monica. He was asked to take pictures and describe the shotguns and describe the case. He was never asked to find that one witness, and that was an interesting thing. Mr. Nickel had worked there. That was, again, a preemptive strike by the defense to try to diffuse the effect of this bombshell. Ms. Erdely came in to talk about the alibi, what I call the alibi route. And that is the route that the defendants took after the murders in order to cover their tracks, create an alibi, and get rid of evidence. Ultimately, the difference between her driving time and the people's driving time is 1 minute. So for the benefit of my argument after lunch, let's say it took 50 minutes, like Ms. Erdely said, to drive all the places the defendants said they drove. The activity time, of course, is different. She substituted her own time periods for how long everything took. Mr. Smith came in and testified that he hated Jose Menendez, and I told you earlier about the conversation with the defendants on approximately Tuesday, the 22nd of December, wherein the $5 million policy was discussed. Dr. Cox was the gentleman who saw Mrs. Menendez for 12 one-hour sessions alone and had some pretty nasty things to say about her. And I asked him, Dr. Cox, what is the appropriate way for a woman to react and to act when she finds out her husband's been cheating on her for a third of their marriage? And he didn't have a very good response for that. Dr. Emery is the doctor who prescribed medication for Kitty Menendez, which is interesting, and we don't dispute that she took medication, but it's pretty clear, both from the coroner and also from the testimony of the defendants, that she wasn't taking medication at the time of her death or in the months preceding her death. And then that brings us to the defendants, and I will address that after lunch.
All right, we'll recess until 1:30, ladies and gentlemen. We'll start coffee at 1:30. Earlier than that, don't discuss the matter with anyone. Don't form any final opinions about it. We'll see you all back here so we can start promptly at 1:30. Argument of the district attorney.
Thank you. It's always been my feeling that in civilized countries they give you 2 hours after lunch for a nap, like in Italy, but unfortunately we don't do that in this country. This is the hardest time for any attorney to argue because everybody's just had lunch, and so please, I understand if you are a little drowsy, and I'm going to be done in under an hour. I'm going to briefly go through the witnesses who were presented in rebuttal, and although you just heard from them, and they're probably the easiest ones for you to remember, they made some points which I think are significant. The people presented Mr. Grant Walker. Mr. Walker was the spa repairman who said that he saw the defendants playing tennis at their home on Saturday, the 19th of August. The reason he's important is because it's the testimony of the defendants that they were out buying ammunition on that date and that they stayed away from the home until approximately 4 o'clock, when they could no longer keep away, and they came home hoping they would miss their parents because their parents were going to go on this fishing trip, and of course we know that they did go on the trip. Now, a lot of the defense rebuttal case was spent trying to discredit Mr. Walker. Mr. Walker is a guy who cleans and repairs pools and spas, and the defense wants you to believe that he's a publicity hound, that he's got an axe to grind. But it seems that the only axe that he has to grind is that he's offended by what's going on here. And he indicated when he called up Michael Jackson and he used the name Fred. And if you listen to the tape, you'll notice that Michael Jackson calls him Fred. Well, it seems to me that if he was trying to garner publicity for himself, he would have used his name and perhaps given himself a plug. And so it seems to me that whoever might have heard him on Michael Jackson would have a tough time calling up Fred the pool man to come in. But Mr. Walker said something really significant, and I know there are a couple of you jurors who don't understand what he meant when he said this. But he said, "I remember where I was when I heard that President Kennedy had been shot." And that was very significant because for those of us who remember the fact of hearing of President Kennedy being shot, you remember exactly where you were, you remember who was around you. You might not remember what color shoes you had on, but you remember that day. It was a very significant day in the history of this country. And when Mr. Walker said, "Hey, I remember where I was when I heard President Kennedy was shot," and he made a comparison that this was similar to him in its shocking value. He was very genuine in his testimony. And the reason the defense spent so much time in their rebuttal case trying to discredit him is because his testimony is very damaging. It's interesting to note that the defense called Mr. Heffernan as a witness, and Mr. Heffernan damaged the defense just as much as Mr. Walker. But since they'd called him, it was kind of hard for them to say, well, we called him, but we think he's a big liar, or he's a publicity hound, or something like that. But just like Mr. Walker, Mr. Heffernan punched a big hole in the defense case because he had testified on another occasion, not in front of you, but it was brought out that he testified in August that Eric Menendez had a tennis lesson on August the 18th. And the way he could pin it down is that Eric Menendez said he was going on a boat trip the next day, and Mr. Heffernan was pretty clear about that. Now, he tried to back away from that statement here in front of you, but when impeached by Mr. Kuriyama, it's clear that in August in this courtroom, Mr. Heffernan testified that the way he knows he gave that lesson on the 18th and not the day before is because Eric Menendez said, "I can't see you tomorrow, we're going on a fishing trip and I'll call you later." So, Mr. Walker came in, and Mr. Walker, who the defense wants you to believe is this publicity hound, whose wife may have combed his hair in the hallway, and I submit to you that almost everybody who would take the stand in this case would probably comb their hair before they took the stand. That's just human nature. It doesn't mean that you're a publicity hound. Mr. Bartek came in to substantiate the fact that he had in fact sent Mr. Walker to the Menendez home to repair the spa. And Mr. Bartek and Mr. Walker are just two working guys. They're just regular old people. They have no axe to grind. They just came into court. Mr. Walker, it seems, because he was offended by what he knew about the case and what he knew from his own personal knowledge about the events of the 19th of August. Then Ms. Pizarczyk. Now, I'm sure the defense has a lot of bad things to say about Jamie Pizarczyk. Again, I'd like to reiterate that I don't know that it's that unreasonable for a young woman to take offense at the fact that her boyfriend is a murderer. I mean, I just really don't think that having a boyfriend who's a murderer is a desirable quality in a mate. And although there are many murderers who do have mates, I'm sure many women would consider a man who's murdered his parents to be someone you don't want to be engaged to anymore. The interesting thing about Ms. Pizarczyk is that the defense is going to attack her credibility, and yet in the area where she hurts the defendant the most, he admitted she was telling the truth, and that is the bribe that was offered to her. She was offered a bribe, and the tape recording is her statement of what happened. Lyle Menendez asked her if she would take the stand and testify similarly to a scene out of a movie. And once again, a lot of what Lyle Menendez talked about, he talked about The Godfather during his testimony too. When I asked him about going to visit the Mafia in New York, how did you know it was the Mafia? Was it like the movie The Godfather? Yeah, that's right. He asked Jamie Pizarczyk to replicate or to describe a scene from a movie called At Close Range, in which a man sexually assaults his son's girlfriend. And she said, no, I won't do it I won't do it. And it was indicated to her that money would be paid to her, and she said no. Now, it seems to me that would be a small lie for her to tell to help out her boyfriend. And if she's a money grubber, as the defense is going to portray her, then it seems to me that that would be an easy way to make money. I think there's another way to look at Ms. Bozanich. Ms. Bozanich, I think, genuinely loved Lyle Menendez, and the defense is going to say she loved him for his money. But the whole time she was with him, she was working. And when they bring in her work schedules and you look at all the days that she worked as a waitress in that restaurant, while her boyfriend was flying back and forth from coast to coast and occasionally attending class at Princeton University, you wonder who was the one who was working hard and who was the one who was a privileged, spoiled brat. So Ms. Bozanich is going to be attacked by the defense, but when it comes to the issue of whether or not she was offered a bribe to lie in this courtroom, she said, no, I won't do it. And Lyle Menendez admitted during direct examination that, in fact, he had made that offer to her, and that she's telling the truth about that fact. The other thing that Ms. Bozanich told you was that the thing about the hairpiece, that she'd had a conversation with Eric Menendez in his bedroom that she specifically recalls, and he indicated that he knew his brother wore a hairpiece. The defense, believing that they'd struck gold, produced her work records, and she said, well, I think it was when I saw Hurly Burly. We've entered into a stipulation that the play Hurly Burly occurred in November, December of '88 and January of '89. The fact that Ms. Bozanich made a mistake about when this conversation occurs is something that's pretty understandable. She indicated, and Lyle Menendez himself indicated, that she was flying back and forth all the time. And I think Ed Fenno also testified that Ms. Bozanich was often at the Menendez home and then gone again. So it's not surprising that she wouldn't be able to remember exactly when this conversation occurred. And if you had had a conversation in your life with someone that at the time was not significant, and then later on you found out that it could be significant, and this thing about the hairpiece is obviously now significant, you might have a difficult time pinning it down too, especially if you traveled a lot and knew that you'd been in California on several occasions but didn't know when. So for the defense attorneys to jump up and down and get excited about the fact that she was working in March of '89, I think is to her credit that she worked that hard. It shows that she was at this restaurant for days on end, working at the restaurant. She was mistaken about when the conversation occurred, but if the defendant's willing to admit that she told the truth about being offered a bribe, why is she now a liar when it comes to this particular fact? The other thing she indicated is that Lyle Menendez had asked her to gather cases, and the defense made much about the fact that she gathered cases in which people had gotten off. And so they brought in a legal expert, someone who graduated from Yale University Law School, which is one of the finest law schools in this country, an editor of the Law Review, which is very difficult to do. You've got to be in the top of your class. And it took somebody from Yale University who was on the Law Review to explain these concepts to you. Lawyers go to school for 3 or 4 years to learn legal terms. It's very clear that Ms. Bozanich is not a lawyer, and gotten off is in the eye of the beholder. If you are charged with a crime and there's only one crime you're charged with and you are found not guilty, you got off. But in a case such as this, when you could be convicted of first-degree murder, second-degree murder, voluntary manslaughter, involuntary manslaughter, there is a huge range and there's a huge difference there. And so what one person might consider gotten off is another person's terrible conviction. But I think it was very clear that Ms. Bozanich's sophistication in the law was far different from the legal expert who was called in to try to explain this to you. And it's very clear that gotten off is not a legal term. It is something that is used by laymen to say the person wasn't convicted of everything that the prosecutor was asking for. But I think that there's a very logical explanation for that. And in fact, I asked the legal expert, whose name I can't pronounce, where do lawyers go to learn the law? Lawyers go to cases to learn the law, the same kinds of cases that Ms. Bozanich Xeroxed for her boyfriend. And she said that there were little synopses at the front of the cases that she read. And the legal expert had to concede that, yes, these cases do have little synopsis at the beginning, which sums up what the case is about. So the thing is that Ms. Bozanich gives damaging testimony, and I'd like to point something very interesting out. In this case, whenever the prosecution can prove something conclusively, the defense will admit it. Whenever the prosecution has to prove something based upon the credibility of the witness, the defense goes after that witness as if the witness were Attila the Hun. The witness is a liar, the witness is motivated by greed, or the witness is a horrible person. But none of these witnesses that have come forward to testify have ever been convicted of murder. They're not murderers, they're not felons, they are human beings. And the people in the courtroom who have the motive to lie are the people sitting over at the end of counsel table. They are the ones with the motive to lie. So keep in mind the fact that just because a person comes in here and says something, and just because the defense attorneys are able to confuse them, I mean, that's what attorneys are supposed to do.
Excuse me, that's improper argument.
Overruled. You may continue.
Any attorney who's been doing this long enough, and I can do it too. I have a 10-year-old niece, and I can cross-examine her and trick her and confuse her all the time. As an attorney, you learn how to cross-examine people. And cross-examining is a skill, and in some cases it's an art form. But just because someone is good at cross-examining doesn't mean that the person who's being cross-examined is a liar. It just means that they are in a battle with someone who's got skills that they don't have. And being cross-examined is very difficult. Some of you probably have friends or relatives. I have a father who's great at cross-examining me. He's not a lawyer, but he was always able to make me feel about this big whenever he started asking questions. So cross-examination is something that is a skill, and Ms. Bozanich was thoroughly and completely cross-examined. But it took a legal expert, somebody who went to Yale Law School, to come in here and explain to you why her using the word gotten off was incorrect. And I don't think that that particular impeachment is very probative in this case. Now, Ms. Surya was brought in to indicate that we know that Ms. Surya, she was the maid who lived in the house, she wasn't there the weekend that the murder took place, but she was there that Thursday night when there was this horrible, horrible fight that Lyle Menendez indicated he could hear from inside of his guest house between his brother and his mother. And if he could hear it from the guest house, which we know is in the backyard, and which is somewhere near the maid's room, how come the maid didn't hear it? And how come the maid never saw any signs of the things that the defense claims have happened in this house? So because of the fact that she lived in that house and lived there for long periods of time, her testimony was important to rebut the idea of this horrible fight occurring on Thursday night. Mr. Brian Anderson came in, and Mr. Anderson told us many things, and one of the things he told us is how the estate paid for the defendant's defense. That was something that came out in cross-examination of Mr. Anderson. Now, the defense, of course, wants you to believe that Mr. Anderson is a horrible, rotten person because he loved his sister and he came in and he testified for the prosecution. I'm sure that testifying for Mr. Anderson was very difficult. It is hard even for me to imagine what it would be like to be a relative of the people in this case, because I'm sure that all of these people loved the defendants. And it's very clear from the testimony of the Buralts and people like that that they did love the defendants. But Mr. Anderson came in order to contradict the horrible picture painted of his sister Kitty. He was the closest one to her. She told him her secrets. She discussed things with him. And he was here to give you a brief, small glimpse of the fact that Kitty Menendez was a human being who was not all bad. And that was why Mr. Anderson was here. And coincidentally, it came out during cross-examination by Ms. Abramson that Mr. Anderson was one of the key people in negotiating the fees for the defense attorneys. And Mr. Anderson indicated that the defendants lied to him and told them that they hadn't committed the crime. And then sometime after he had arranged for the fees to be paid through the money of his dead brother, dead sister, and brother-in-law, then he was told that in fact they had done the crime. He is another person to whom the defendants specifically lied, and he indicated that he had spoken to each of them and they had told him they didn't do it. So Mr. Anderson's testimony is there somewhat to portray Mrs. Menendez as a human being who was not a rotten, horrible person, and coincidentally to explain to you how this defense came to be. Marzie Eisenberg was the secretary of Mr. Jose Menendez, and I think she was fairly frank in her assessment of him. She said that he was often hard on people. She indicated that at times she would even tell him, hey, I think you were a little hard on that person. She indicated that Mr. Menendez was pretty transparent to her, and she could tell if he was in a bad mood. There are people you work with sometimes, and you can never tell if they're in a good or bad mood because they're always the same. And then there are other people you might work with or live with where you can tell all the time, this person's in a rotten mood today, I'm going to stay away from them. Marzie Eisenberg indicated that Mr. Menendez was one of the latter type. He was the kind of person where she could tell if he was in a good or bad mood. And she said that on August the 18th, there was nothing remarkable about him. Well, if on the night before, Lyle Menendez had threatened to expose his father as being a child molester to everybody in the world, it seems to me that he probably would have been in a bad mood. True or not, any person in that particular position who had a temper, and we know that Mr. Menendez had a temper, would have been in a rotten and noticeable bad mood on August the 18th. Ms. Eisenberg was also called and did testify that Mr. Menendez had good qualities to him. After the picture painted by the defense, I think it's incumbent upon the prosecution to try to set some sort of balance to this horrible picture that's been attempted to be painted by the defense attorneys. The other thing that Marzi indicated, and I discussed this earlier, is the fact that in the fall of 1986, Eric Menendez was alone with his father many times in Calabasas while the mother was closing up the house in Princeton, a period of time during which Eric Menendez said he had no sexual contact with his father. Karen Farrell was here to testify on behalf of the Menendez parents. She indicated that she had witnessed Mr. and Mrs. Menendez hug their children. She indicated as well that she had talked to Mrs. Menendez on the Tuesday or Wednesday of the week of their homicides, and that she was invited to play bridge with them, that she called and said, "I don't think we can make it," and Mrs. Menendez urged her to come anyway. Again, this belies the picture painted by the defendants of the events of the week of August 15th through August the 20th. And Detective Zoller was called for several things, but basically to impeach Ed Fenno about his statement to the prosecution and the police, wherein he said that Mr. Menendez was very unhappy about the fact that Eric Menendez had turned down Berkeley. Now, the defense witnesses, and I'll go through them briefly, Mr. Slotkin was here to talk about the soundproofing. He was here to talk about the defendant's helplessness. I'd like to ask you again to consider if Lyle Menendez, and remember, Mr. Slotkin met with both the defendants. If Lyle Menendez was on the East Coast from the 25th or 26th of August through at least the 6th or 7th of September, when was it he talked to Mr. Slotkin about things such as buying the car? Remember, Mr. Slotkin said that he talked to him about buying the Porsche. Well, Lyle Menendez bought the Porsche on the 8th of September in Princeton, in the Princeton area. There's no evidence he was in Los Angeles between the 25th of August through that time period, except for the one day he came back here. And it's clear that's not the day when he met with Mr. Slotkin. So it appears that they met with him before they went back east and before even the memorial service in Los Angeles. I've discussed the legal expert. Mr. Custer was here to indicate that Jamie Pizarczyk was either lying or mistaken about her engagement to Lyle Menendez. I believe she said she didn't remember it. It could also be that Ms. Pizarczyk is embarrassed, and I think that I might be embarrassed as well to have been engaged at one time to someone who turns out to have been a murderer. It's not the kind of thing that you want everyone to know. And yes, she did come in and testify, and Mr. Custer very briefly gave testimony that at one time she was very excited about being engaged to Lyle Menendez. This was at a period of time before Lyle Menendez had told her that he'd killed his parents. Mr. Peckins gave you a video. Mr. Peckins was the one with the video of the neighborhood. And I think what it showed is that the neighborhood was a very nice neighborhood. The houses are very attractive. I think the purpose of the video is to show that the houses are close together. Therefore, the shots from the shotgun would have been heard by the neighbors. Let me just say this. If you have an alibi for a particular event, one of the things that you need for the alibi is a time when the event occurred. In other words, if they had stabbed their parents and there was no noise, and there was no way to establish when their parents had died, then their alibi wouldn't be any good, because their alibi was for a period of time from 8 o'clock at night to approximately 11 o'clock at night. So unless the neighbors heard something, there was no way for their alibi to have any meaning, because they have to pinpoint the time that this crime occurred. So rather than being something that Dr. Burgess indicated was very, very stupid, there's no way to have your alibi work unless you can establish precisely at what time the crime occurred. Mrs. Ingram and Mrs. Valdry were the people on Mr. Bartek's route. He indicated on a piece of paper 3 names of people he serviced on Saturdays. He thought that perhaps 2 out of the 3 he would have serviced in 1989. Mrs. Ingram said not in 1989. Mrs. Valdry said yes, in 89 he serviced me. Now, I think the defense is going to say that Mrs. Valdry is a liar, because she told the defense investigator, Ms. Erdely, indicates that Ms. Valdry told her something else. Now, why would Ms. Valdry come in here and lie? I mean, what possible reason would she have to come in here, raise her right hand, swear under penalty of perjury to tell the truth, and then lie about when her pool man comes? It seems to me that there's no indication she knows anyone in this case. There's no indication she has an axe to grind. She actually supported Mr. Walker in her testimony, and I don't know if it was sloppy bookkeeping on the part of Ms. Erdely or what, but the idea that that lady came in here and lied is extremely offensive. Why would she do that? She didn't do that. It's just that the defense made a mistake in calling her. Now, I mean, there's just no reason that you would lie about when your pool man comes to your house. What possible motivation could she have? Mr. Heffernan, I've indicated before why his testimony is significant. He's here to say that he's not the guy that Mr. Walker would have seen. Well, I think it's pretty clear that these defendants were not playing tennis exclusively with Mr. Heffernan. And the gentleman that Mr. Walker saw was someone with dark hair. By Mr. Heffernan's own testimony, he wasn't with the defendants on Saturday, that particular Saturday. So it's entirely possible that what Mr. Walker saw is what he saw, which is a man with dark hair playing with the defendants. We know from Lyle Menendez's testimony that during his life he's had over 50 coaches, and that he was coached by many different coaches at the same time, on the same occasions. So Mr. Heffernan actually ended up turning out to be a pretty good witness for the prosecution because of the fact that he indicates he gave Eric Menendez a tennis lesson between 9 and 11 or 9:30 and 11:30 on the morning that they were supposed to be in Santa Monica and then on the way to San Diego. And the KABC tape I've already discussed. Now, the last part of my argument. In a book called Mein Kampf, the author once wrote, "The great masses of the people will more easily fall victims to a big lie than a small one." The judge is going to instruct you at the beginning of the instructions on how you view the witnesses in the case. And as I said earlier, the defendants, once they take the stand, are witnesses. He's going to say to you, "A witness who is willfully false in one material part of his or her testimony is to be distrusted in others. You may reject the whole testimony of a witness who willfully has testified falsely as to a material point, unless from all the evidence you believe the probability of truth favors his or her testimony in other particulars." In other words, this applies to the people's witnesses as well as the defense witnesses and to the defendants. A witness who is willfully false in one material part of his or her testimony is to be distrusted in others. The defendants lied a great deal before they were caught. What makes you think they would stop lying now? What makes you think that after all the lies that Lyle Menendez told before in order not to be captured, he wouldn't lie in order not to be convicted? The judge is going to instruct you. If you find that before this trial the defendant made a willfully false or deliberately misleading statement concerning the crimes for which he is now being tried, you may consider such statement as a circumstance tending to prove a consciousness of guilt. However, such conduct is not sufficient by itself to prove guilt, and its weight and significance, if any, are matters for your determination. Another instruction he's going to give you, and I'm just reading parts of these. If you find that the defendant attempted to persuade a witness to testify falsely, you may take that into consideration. We know that Lyle Menendez lied to the police during the 911 call that he placed to the Beverly Hills Police Department. We know that he lied to the police officers who arrived on the scene. We know he lied to Sergeant Edmonds shortly after being taken to the station. We know he lied to Detective Zoller. We know that he lied to family members, specifically at memorial services. And I believe at the Princeton Memorial Service, he actually got up and spoke. Can you imagine the coolness and the nerve that must have taken? To know that you've killed your parents and then to get up and speak as if you were the aggrieved victim. He lied to reporters. He indicated that he talked to reporters and tried to portray himself as the grieving son of these slaughtered people. We know he lied to Brian Anderson in order to get his attorneys paid. We know that, according to the defense, they say he lied to Dr. Oziel. You see, when it's convenient for their purposes and they want you to disbelieve Dr. Oziel, they say, well, he lied to Dr. Oziel. But of course he didn't lie to Dr. Oziel. We know he lied to Jamie Pizarczyk. Now, he admitted that he lied all those times, because can you imagine if he'd come into court and taken the stand and denied that he'd lied? Can you imagine what you would think of him? The prosecution could prove all these different lies, because in proving he did the murder, we proved that he lied. And so he had to take the stand and say, yeah, I lied before. Because if he hadn't admitted he was a liar, you wouldn't have even begun to listen to anything he had to say. You see, the prosecution boxed in these defendants with the evidence, and the defendants have to admit certain things in order to have any chance of getting what they want out of this case. Now, I'd like to ask you to think about the following. If an actor like Robert De Niro or someone like that had 3.5 years to sit and think about a script and 3.5 years to get ready for a performance, do you think he could do it? Do you think an actor, a professional actor, in 3.5 years with only one script to study and one purpose in his life could get ready and act? Well, this defendant is more motivated than any Academy Award seeker because he's motivated by things outside of praise or money or promise. This defendant is fighting for his life. Now, if he was willing to lie and lie and lie to everybody in town, why, in God's name, should you listen to anything he has to say? Well, he takes the stand and he gives a very stellar performance. He cries at appropriate times. He cries and apologizes to his brother, and he says, oh, and I'm so sorry for what I did to you. And I said to him, come on, is that the first time you've had to apologize to your brother? That was done specifically to move you. Now, I went to a movie recently, I think it was called Mrs. Doubtfire, and it's a sort of a light comedy. And I cried through the whole movie because I always cry at movies. And I was sitting there thinking, this isn't real. This didn't really happen. This is a movie. But I still cried through the whole thing because there were parts of it that I found very poignant. Well, likewise, the story, the tale, the script that was given to you by the defendants on the stand was poignant. And some of you might have felt your heartstrings being pulled. But this is from a person who admitted that he lied to everybody in town. Now, going through the events of August 15th through August the 20th, and if I said, if you believe that Mr. Menendez was a child molester, okay, if you believe that, that doesn't mean the defendants are not guilty of murder, because you can't believe what they said to you about the events between August the 15th and August the 20th. Through cross-examination and through the people's case, the people have proved that much of what they said, which occurred during that week, was a lie. And the reason that scenario was developed was in order to play into this unreasonable but honest belief in the need for self-defense. It's absolutely geared towards the voluntary manslaughter and involuntary manslaughter instructions. So, on August the 15th, according to the defendants, Mrs. Menendez ripped off Lyle Menendez's hairpiece, which set in motion the events which culminated on August the 20th. Well, Ms. Pizarczyk indicated in her testimony that Eric Menendez had told her months before that he knew that his brother wore a hairpiece. In addition, it seems to me that if you live with a person long enough, you might notice that their hair is starting to go. You also might notice that the person's not getting haircuts when you're getting haircuts. It seems to me impossible to believe that Eric Menendez did not know that his brother wore a hairpiece. In addition, you've seen a lot of photographs produced by the defense, but have you seen any photographs of Lyle Menendez where his hair was balding? Now, I believe Ms. Pizarczyk indicated when he was 19 years old it was noticeable that he was losing his hair. Where are the pictures from the defense to show how absurd it would be for Eric Menendez not to know that his brother wore a hairpiece? So common sense tells you, leaving aside Ms. Pizarczyk, common sense tells you that this whole thing with the hairpiece is just something that's totally made up. And in addition, you will see the documents, I think it's Exhibit 372, where on the 28th of July, Lyle Menendez had his hairpiece reattached with the fusion method, which is glue. He indicated he had his hairpiece glued on. It seems impossible that this woman, who was approximately 5'4" to 5'5", reached up to her 21-year-old son. Remember, he's 21. He's not a child. He's not a boy. He's a man. And ripped this thing off his head. And he just, stood there and let her rip it off? I mean, you would think that he would have held his head or something like that. So this whole thing is ludicrous. And Ms. Pizarczyk's testimony isn't even necessary in order to find, you just need to use your common sense to see how ludicrous it is. On Wednesday, it doesn't appear that anything of major significance happened, but on Thursday, August the 17th, Lyle Menendez had the big talk with his father. He indicated that after the talk, Eric Menendez found out that his mother had known all along about the abuse and had done nothing about it. There is no indication in anything of Kitty Menendez's that you have heard about or that you will see in her letters that she ever suspected her husband or thought her husband was a child molester. The reason that this is being brought up is because child molesting is such a horrible crime that if you believe Jose Menendez was a child molester, the defense is hoping that you'll ignore the actions of the defendants. Lyle Menendez, and I've said this 3 times, I'll say it quickly once more, he says he heard screaming from inside the guest house as his mother and Eric raced from inside the main house across the yard and upstairs into the 2nd floor of the guest house. But of course, Miss Surya heard nothing. And if the neighbors could hear the shotguns, why couldn't Miss Surya hear the screaming? On Friday, August the 18th, Lyle Menendez indicated that his brother was playing tennis and that he went to him and said, hey, it's not a new day, you can't make this thing go away, and they went to buy the guns. Well, we know from Mr. Heffernan that during the period of time when they were supposed to be buying the guns, that in fact he was giving a tennis lesson to Eric Menendez. We know from the defense preemptive strike and also from the stipulation of the prosecution that they didn't sell handguns at the Big Five. And Eric Menendez was very clear that they picked them out, they were about to buy them, and the man told them about the 14-day waiting period. That is a big lie. They said they went to the Big Five in San Diego for reasons which defy common sense. The reason they went to San Diego so they wouldn't be found out, not because they just happened to find themselves there. Eric Menendez, he had another false ID, but he decided to use Donovan Goudreau's because he looked like Donovan Goudreau. You have a copy, it's a Xerox copy, but you have a copy that's going to be an evidence of Donovan Goudreau's driver's license, and there is no resemblance, aside from the fact that they're both white males, between Donovan Goudreau and Eric Menendez. The reason he didn't want to use his false ID is because it had his picture on it. And when you see this exhibit of Donovan Goudreau's, you'll see that the prosecution can get copies of driver's licenses even after the license is lost. Consider the fact that they used a false identification, a false address, a false birthplace in a city 2 hours away. And I believe Detective Zoller testified that there were approximately 100 gun stores that sold shotguns within a 10-mile radius of the Menendez home, which is where he had concentrated his efforts. On August the 19th, according to the defendants, they went to Van Nuys in the morning to buy more potent shotgun shells, from birdshot to buckshot, because they felt that they might, these non-experts in the use of shotguns felt that they needed stronger ammunition, and so they went and they bought buckshot and drove around. I think they went to a mall out here and had lunch, and then they returned around 4 o'clock in the afternoon. Well, Mr. Walker was really specific. I remember the day that I heard that President Kennedy was shot. I remember hearing about this. I know I was there on Saturday. And he called up Michael Jackson incensed and repeated under a pseudonym what he had heard and what his impressions were of what he saw on August the 19th. The defendants indicated that this fishing trip with their parents was something that they were very terrified of, because they thought maybe the seedy-looking fishing captain and his 2 mates were going to, I guess, make them walk the plank or something, and that somehow they would come home and Mr. and Mrs. Menendez would say, well, we went fishing and they got lost and we don't know where they are, and they just go on with their lives. Now remember that in order for you to find the defendants guilty of voluntary manslaughter, you've got to find their belief in the need to defend themselves to be honest. And honesty is something that you can never use to describe Lyle and Eric Menendez. They are the antithesis of honest. On August the 20th, the defendant said that Perry Berman told him that his father had told, this is very complicated. Lyle Menendez said in his testimony that when he called Perry Berman at between 4 or 5 o'clock in the afternoon, Perry Berman told him during that conversation that Mr. Menendez had said, A, that the boys weren't home, and B, that they couldn't go out that night. First of all, for Mr. Menendez to think his sons weren't home, from Lyle Menendez's own testimony, which of course isn't true, but even from his own testimony, he said he never went into the house that day. He stayed out in the guest house. And it's very confusing because you may want to analyze everything Lyle Menendez said as being true, but those events between August the 15th and August the 20th are not true. What happened is during that period of time, they were scheming to kill their parents. And although they did some of the activities they've testified to, like going to San Diego to buy the shotguns, They didn't do it for the reason that they said they did. Now, can you imagine if these defendants had come in here and said, we didn't purchase the shotguns? Well, I have all the evidence to prove that they did, so then what do you think of them? You see, Lyle Menendez had to admit that they bought the shotguns, and then he had to come up with an explanation. And the question is whether you find that explanation to be credible or not. The description of how the murders occurred is something that I'd like to discuss with you now. Dr. Golden's testimony was fairly precise, and he indicated that there were 6 areas of wounding to Mr. Menendez and 10 areas of wounding to Mrs. Menendez, and I'm going to go through them briefly. Mr. Menendez had a contact wound to the back of his head, which Lyle Menendez did finally admit he had done, but didn't really recall the details of it. Mr. Menendez had a distant shot to the right arm, which entered through the underside of the arm and fractured his humerus. Mr. Menendez also had a wound to the back of his right forearm below the elbow. And you can see photographs of these, so you don't have to take my word for it. So he's got a wound entering his arm here and a wound entering his arm from here. And of course, if his arm was like this or like this, there's no way of telling exactly where the arm was. But if Mr. Menendez was seated on the sofa and someone was standing behind him, that would as well explain this wound to his right forearm. Mr. Menendez also has a very interesting wound, which the defense cross-examined the expert about. And what that was is an entry wound above his left knee that went out. Now, it seems to me from the description given by the defendants of how they killed their parents that they in no way ever described how that particular wound entered the inside of his left thigh and exited on the outside of his left thigh. But the logical explanation for that is that that wound was inflicted from behind him by his assailant. In other words, he was sitting on the sofa, his foot was on the coffee table, his left leg was bent, and someone from behind him shot through this wound. Now, the 6th one is not a separate wound, and it's just an abrasion to his chest. I believe it was, the coroner thought that there was one pellet that entered his chest, and the coroner thought that that was related to the wound that went through his arm as well. So on Mr. Menendez, we have 5 distinct wounds, 5 distinct shots. Mrs. Menendez. Mrs. Menendez had a contact wound to the left cheek which contained bird shot. Lyle Menendez admitted that he went back in after reloading his weapon, and don't you think reloading his weapon shows a great deal of malice and premeditation and a desire to make sure that she died. Contact wound to her left cheek, which according to him was the last wound. That's wound number 1. She also has a wound to her right cheek and eye, which you can see in the photographs, and she's got a wound to her right jaw and collarbone. The coroner indicated that these 2 wounds to her eye and her chin and collarbone could have been the same. Now, interestingly, there's a part on her face right here that doesn't have any wounding. And so I think, and you know that her right hand had pellet wounds in it, and so it might be that she had her hand up like this when that blast hit her. But the interesting thing about that is that these pellet wounds on her hand were through and through, and yet in the area that would have been covered by it, there are no marks on her cheek. But giving the defense the benefit of the doubt and calling this wound to her right side and this wound to her jaw one shot. Go on to the wound number 4, which was the bird shot to the left ear area. Remember, the coroner said that her left her left shoulder was blown away, and that there was bird shot in her neck right here on the left. And he felt that this wounding was from one shot. Well, if it traveled across her shoulder and went up into her neck, it seems that that was done from some distance because he indicated it was a distant shot. But the interesting thing about this wound is it's bird shot. Now remember, the defendants, before they went in first to shoot their parents, they went out to the car, they unloaded what was in their guns, and they loaded with buckshot. So when we do the math at the end, you'll see that this wound, it takes off her left shoulder, goes into her neck, and the contact wound right here on her face were probably administered at the same time. Wound number 5 is to the upper right arm and right forearm. You'll see a photograph of her where there's a wound across her forearm and takes off part of her upper right arm. The coroner indicated that although there are 2 defects there, that's probably the same shot, and that would be wound number 5. Wound number 6 was a distant shot to the left chest and arm. You can see that some of the pellets lodged in her left breast. There was also some wounding, I think, across the left forearm. There's also wound number 7, which is a distant shot to the upper left hip and thigh area. And there was also a shot to the left knee behind. Well, that means she was shot from behind. Now, remember Lyle Menendez when he said, and I'm sure he sincerely regrets this, "My mother was sneaking away." This woman was shot from behind. And then wound number 9 was called by the coroner a graze or a gutter wound. And that was caused by a cluster passing by. And it sort of just took out some skin as it went by. But the interesting thing about this is that the wound goes up as if towards the head, which would imply that the shooter, if she was standing when she got this wound or seated, that the shooter would have had to be on the ground. So it seems like she was in a different position than standing or seated when she got the wound to her left leg. And I'm not even going to count that as a separate wound. And the last wound is wound number 10, which was the wound to the hand, which, as I indicated, could have been, and it would make sense that she would have covered her face with it. And yet, even though it goes through and through, there are no marks on the area that would have been covered. So if you combined, if you have wound number 1, 2 and 3 were probably the same. You have 4, 5, 6, 7, and 8. I'm not going to count the graze wound on her, and I'm not going to count the wound to her hand. So she was shot 7 times. Mr. Menendez was shot 5 times. That's 12. And then we have 2 in the door, which is 14. Now, the guns each hold 6 rounds, and even though the defendants were very unclear as to whether they had fully loaded their guns, for their benefit, we will say that each gun was fully loaded with buckshot when they first went in. Well, that's 12 rounds, and we know that 14 rounds were fired. And we know that 2 rounds that hit Mrs. Menendez, the wound to her cheek and the wound to her shoulder and her neck, were both bird shot. And so if you do the math, it's very clear that she wasn't shot once when they came back into the room. She was shot twice. Now, the other thing about August the 20th, which is remarkable, and I'm almost done with my argument. Remember Ms. Erdely came in and she said, well, I got a videotape from the prosecution, and we went out and we did the driving time, and it took 50 minutes to drive from the house to the theater, back up to Coldwater and Mulholland, and then down to the Taste of LA. It took 50 minutes to do that. Interestingly, if the murders occurred at 10 o'clock and the phone call to Perry Berman is 11:07, that gives the defendant 67 minutes to go to the theater, buy the tickets, go to Mulholland and Coldwater, find a place, hide the guns, come back down into the flatlands, get rid of their clothes because they weren't going to go see Perry Berman with blood on them. Remember, Dr. Burgess testified that they would have had blood on them as a result of the shooting. You can't go meet your alibi witness with blood on you. It could be very incriminating later. They did not do that after. They did it before. And then they went to the Taste of LA, where Lyle Menendez indicated he got lost a little bit. Now, when Ms. Erdely did it, her activity times and her driving time came out to 66 minutes, which means that it's possible. But unfortunately, she assigned her own activity time instead of the activity time testified to by Lyle Menendez. Lyle Menendez indicated that first of all, he's unfamiliar with the roads here in Los Angeles, and if you've ever been on Coldwater, and you can see from the videotape, it's a winding road and it's not well lit. He indicated that after they murdered their parents, they waited for 5 to 10 minutes at the house for police. They discussed what they were going to do now for approximately 2 minutes. They evidently recovered from their automaton, fearful state. They went in and picked up the shells, which took a minute, and they left the house. The best they do with this particular activity is 8 minutes, and that's giving them 5 minutes to wait at the house, 2 minutes to discuss what to do, and 1 minute to pick up the shells. So you've got 8 minutes for activities. If the driving time is 50 minutes and the activity time is 8 minutes, you're up to 58 minutes. You've got 9 minutes left to do everything else. They go to Century City, where Lyle Menendez indicates he parked at a parking meter. There are no parking meters outside of Century City. There is no taxi place. There's no place where you can leave a car unattended. And Eric Menendez went with him up to buy the tickets. He indicated it took approximately 10 minutes to park the car, go to the box office, and purchase the tickets. Well, at this point, there are only 9 minutes left. So already, by then, he's used up his allotted activity time. Then they went up to Mulholland, they buried the guns, and in 2 minutes, this was all accomplished. Detective Zoller testified that there was a lot of brush up there. There's no lighting. I believe, but I'm not positive, that Eric Menendez said he went about 150 feet down the hill in order to hide the guns. And this all took 2 minutes in the dark, no lighting, with a lot of brush. But still, giving them that, they are now 3 minutes over their activity time. Then they went and got rid of the clothes, and I believe this activity took approximately 5 minutes. So they're now 8 minutes over their activity time. Lyle Menendez indicated that on the way to the Taste of LA, they got lost for a period of minutes. So let's give them 2 minutes for getting lost. They're 10 minutes over the amount of time they would have had to do this. It would have taken, they wouldn't have made the first call to Perry Berman till 11:20. What actually happened is they went to the movie theater beforehand to buy the tickets. And one of the things that's a problem for the defense in this case is that it's very clear they had to have gone to the movie theater because Lyle Menendez was able to tell the police License to Kill was sold out. Well, you all know from going to the movies that when you call a movie theater, you get a recorded message. And they don't tell you, oops, License to Kill was just sold out. The way you find out a movie is sold out is you go to the theater. See, we can prove then that Lyle Menendez and his brother went to the theater because shortly after the homicides and the police are called, they're telling the police License to Kill was sold out. At the time, it seemed like a clever move because it proved that they went to the movie theater. What really happened is they went to the movie theater before they killed their parents and they bought the tickets. And I believe the tickets were given, and I think the testimony was, is the tickets were given to Eric Menendez, who put them in his pants pocket. That's where you put your movie tickets if you don't carry a purse like a woman does. All right, so puts the movie tickets in his pants. They do the murder. They go and they change their clothes. And what does Eric Menendez do? He changed his pants. He threw his pants away in the dumpster at the gas station. There went the movie tickets. Now, it turns out to be a very fortunate thing because if he hadn't thrown away the movie tickets and he'd given them to the police, that would have proved that the movie tickets were bought beforehand. But now they can come into court because he made this mistake and say, we went to the movie theater afterwards and we found out what we found out then. But we know that there was not sufficient time between the 10 o'clock when Mrs. Lord said that she heard the sounds and the 11:07 record, the U.S. Sprint record that we have. See, it's another thing we have that they have to explain. We have the U.S. Sprint record, which shows that at 11:07, a phone call was made to Perry Berman from the Santa Monica Civic using Mr. Menendez's Sprint card. So this particular thing, this whole story about making up the alibi afterwards and all the things they did is another lie. So, where does that leave them? Well, what it shows is that these defendants have lied throughout. They are lying now, and they will continue to lie as long as they think it will help them keep from being convicted. And I'd like to leave you with this. I don't know exactly how the defense is going to explain the December 11th tape, but in the words of Lyle Menendez, and I'm going to read to you portions of the transcript from the December 11th tape. He says, because even the planning out of this, the reason it took such a short period of time to figure it out was, one, because it could have happened at any moment. He goes on and he says, it was done so quickly and so sort of callously almost, because one, if you thought about it too much, the feelings of not having your parents around and so on would get in the way of what was more important, which was helping your mother, really. And then he says, I think one of the biggest pains he has, and he's talking about his brother Eric, is that you miss just having these people around. I miss not having my dog around, if I can make such a gross analogy. Now, the defense is going to try to tell you that these are the words of Dr. Oziel, but if you listen to the tape, Dr. Oziel never uses the word plan, and he never compares killing Mrs. Menendez, or killing Mr. Menendez, to getting rid of a dog that you don't like. The truest statement of Lyle Menendez's state of mind is contained on that tape, and although the tape is clearly made to try to mitigate or to try to minimize his moral culpability, When Lyle Menendez uses words like plan and uses phrases such as, "I let my brother sleep on it for a couple of days," it's very clear that this was a planned, premeditated slaughter of two people who were keeping Lyle Menendez from doing what he wanted to do, which was not go to school and spend a lot of money. He is guilty of 2 counts of first-degree murder. He is guilty of conspiring with his brother to commit those murders. And he's guilty of killing 2 people, two people of first-degree murder. He's guilty of doing it by lying in wait and taking his parents by surprise in order to accomplish his goals. Thank you.
All right, thank you, and we'll take a recess, ladies and gentlemen, to permit the lawyers to set up for the next phase of the argument. If you would return and be ready to return at 10 minutes to the hour. Don't discuss the matter with anyone. Don't form any final opinions about it. If you would be available in the jury room so we could have you come in here at 10 minutes to the hour. And I'd ask that counsel remain. The jurors have left. There was some question in regards to the defense argument.
Yes, Your Honor. It's my understanding that Mr. Burt intends to play videotapes of some of the testimony of some of the witnesses. I think it's just 2 of the witnesses in the case, and the people object to that.
Well, first of all, is that what you intend to do?
Yes, I have a very short segment of Lyle Menendez's testimony and an even briefer segment of Dr. Oziel. I think it's less than 3 seconds in length on Dr. Oziel and less than 15 or 20 seconds on Lyle Menendez. And I intend to use that to talk to the jurors about how they judge demeanor as one of the factors in determining the credibility of a witness, and in response to the prosecution's argument that apparently Lyle Menendez was modeling himself after Robert De Niro and practicing for his testimony. So I do intend to place some emphasis on demeanor, and I think that the most effective way to do that is to bring to mind to the jury something which they saw and which I can recreate in a courtroom in much the same way that the prosecutor can put up her bloody photograph and use that as a basis for her argument. So I think it is proper evidence. It's certainly something the jury heard and saw in testimony. And I think it's an appropriate way to highlight the point that's being made. I'm certainly not asking that the video go into the jury room, but I think it can be used properly for illustration purposes.
Well, the bottom line is that the jurors saw this testimony, and perhaps they did not see precisely what's on that video, and now you would be presenting to them something they didn't see. They could have easily been looking away at the moment that the video camera caught whatever it was the witness was doing that you want to show to them, and you were in essence showing them something that perhaps they didn't see.
Well, hopefully they were following the court's instructions that they were here to listen and to evaluate the credibility of witnesses.
Well, I hope so too, but that doesn't mean they were watching the witness every moment. Sometimes they look down, sometimes they look at the lawyer asking the question, sometimes they look at the lawyers at the counsel table, sometimes they do other things. So my first observation is that you would be introducing something that they might not have seen. They did hear the testimony, they've heard all the words spoken, they've seen the demeanor of the witnesses, perhaps not the exact expression that you want to display, because, as I said, some of them might not have seen that. And at this point, you are introducing something that perhaps some of the jurors have not seen, and is introducing evidence outside of the trial to that extent, which would possibly be the case. Besides that, it tends to accentuate one thing over another, and is, at this point, the court, in its exercise of discretion, would sustain the prosecution's objection to
well,
use of it.
could I be heard briefly on that? In terms of the court's analysis that it tends to insinuate one point over another, I don't see how that can differ from the prosecutor having a photograph up on the board throughout her closing argument, as she did, and the photograph is still up there. That is the purpose of closing argument, to insinuate what, in counsel's view, is a important piece of evidence.
Yeah, this is a piece of evidence.
It's argument, and so is the demeanor of the witnesses. And I don't think it's the right answer to say that, well, maybe the jury was not paying attention.
No, I didn't say that. I just said they may not have been looking at the witness. They certainly didn't have the same perspective as a TV camera, and they saw something different. And whether they were looking at the witness at the exact moment that you now want to portray is something we'll never know. That doesn't mean they weren't paying attention.
No, but that's not what it's being used for. It's not being to say at this precise moment in time, these witnesses did something that indicates their demeanor at that precise moment. It's something that if at some point in time the jury was paying attention, and we have to presume they were over 6 or 7 days.
Yeah, none of my comments have anything to do with their paying attention. It has to do with whether or not they happen to be looking at the exact moment that you want to bring out in your video, actually seeing exactly what you want to show them now.
But as I indicate to the court, that's not why I'm attempting to use it, to bring to their attention something that they may or may not have seen. It is a point that was, and their demeanor was the same throughout. And the worst that could happen by use of this is that the jury or some of the jurors would see something that they should have been looking at to begin with, which is paying attention to the testimony. So that's the only harm done. And it is argument. It's not being offered for any other purpose than to highlight an argument, which I intend to make. And I think an appropriate one in light of the prosecution's emphasis here on play acting. It's the only way to accurately recreate demeanor and to bring that back to the jury's mind in a way that is effective.
All right, there is no need to recreate the demeanor. The jurors were here to see it and observe it and form their own opinions based upon the entirety of it, not just one little snippet. So the court's observations are those that will control it. The court's ruling and the people's objection is sustained. All right, we'll resume in 10 minutes. Presented, the jury's back in the jury box. Now we'll have the beginning of the defense argument. Mr. Burt.
Thank you, Your Honor. Ladies and gentlemen of the jury, when it boils down to it, when all the lawyers in this case finally stop talking, I think you're going to see that the real issue in this case is what was going on inside the minds of two young men on August 20th, 1989, when they opened fire with two incredibly loud shotguns in the middle of a residential area about a mile away from the police station, and then ended the lives of their parents. Was this an act, as the prosecutor says, of two cold-blooded killers who were bent on committing the perfect crime and thereby to satisfy their lust for greed or their desire to gain back control that they had lost to their parents, or now, as the prosecutor claims, over some dispute concerning a camera recorder? Or was this instead a response of fear and panic that followed year after year after year of abuse by two bullying parents, an abuse which resulted in that final week that you heard excruciating detail about here, which culminated in Lyle Menendez telling his father that he wasn't going to abuse his younger brother anymore? That's really the issue in this case. And the answer to that question is, or may be, a life or death one for Lyle Menendez. And because of the importance of that question, we spent a considerable amount of time since July, when you were selected as a jury, really exploring all aspects of the case. And it was done because Lyle Menendez's life may be at stake in these proceedings. We do operate in a civilized atmosphere here, but it's important, I think, to realize that what's at stake here may be a life or death decision. And that's why we explored at times what to you must have seemed like mind-numbing detail, It was really just an attempt by both sides to do their best job in a case that has very, very, very important consequences for the people who sit at that side of the table. And it's important now that you as jurors, each and every one of you, understand not only the facts of the case, which you've heard since July of this year, but also the law. And I'm going to be talking primarily to you about the law this afternoon. I will mention some facts. Specifically, I'm going to talk a little bit about the coroner's testimony, and I'm also going to talk about the credibility or lack of credibility of some of the people's witnesses. But primarily, I'm going to be talking about the law this afternoon in the time that I have remaining. And then tomorrow, Ms. Lansing is going to explore with you in detail both the defense witnesses as well as some of the prosecution witnesses, and will respond to some of the arguments that Ms. Bozanich made during her closing argument. But the law in this case is important. The details of the law are important here, however boring they may seem, and especially boring at 3 o'clock in the afternoon. The reason the law and the details of the law are important here is because, as you're going to learn shortly or tomorrow probably from the judge, you as jurors have two basic duties to perform here. And the judge is going to tell you that your first duty is to determine what the facts are. You are sitting as judges, and you are the exclusive judge of what the facts are. The judge cannot tell you what the facts are. Ms. Bozanich cannot tell you what the facts are. I can't tell you what the facts are. You decide what the facts are in this case, and no one can tell you otherwise if you decide the facts are a certain way. That's one duty you have to perform here, is to decide what the facts are. And you've heard conflicting testimony. It's going to be your job as judges to decide what those facts are. And you're also going to hear from the judge that the second duty you have to perform here is to apply the law as the judge gives that law to you, even if you disagree with it. And the law that the judge is going to give to you will be contained in the instructions, which he's going to read to you. Hopefully you'll have a copy of those instructions to take into the jury room with you. Some of those instructions were discussed by Ms. Bozanich. I probably will be repeating some of the instructions she talked about. I don't think it hurts to hear it twice, because these are difficult concepts, even for lawyers. If you understand them already, fine. If you don't, I hope some of the things I'm going to say about the law will be helpful to you. And I'm going to discuss in detail the law, and then, as I say, Ms. Lansing will discuss with you tomorrow how to apply that law to the facts of this case. And as the judge is going to tell you tomorrow, the reason you have to apply the law to the facts of the case is that the ultimate goal here is to arrive at a just verdict. Both sides have a different version of what a just verdict means in this case. The prosecutor thinks a just verdict is for you to convict Lyle Menendez of first-degree murder with special circumstances. And it's her hope that ultimately that decision will lead to another decision which could send Lyle Menendez to the gas chamber. The defense, on the other hand, of course, has a different version of what justice will be in this case. And it's going to be up to you to decide ultimately where justice lies. But it's not a free-flowing decision. You don't just go back and say, well, I think this, or I think this is the way the law should be. It's justice reached within the court's instructions. And that's what guides us through your deliberations, is the law that the court is going to give to you. So what is it legally that you're going to be asked to decide here, and how do you go about doing it? Ms. Bozanich talked to you a little bit about the various options that you're going to have here, and I want to discuss those options with you as she did, but in a little more detail, in hopes that it will clarify for you what decisions you're being asked to make here, because it's not just a decision of is Lyle Menendez guilty or not guilty of murder in the first degree. There are other decisions you're going to have to make, and so I want to make sure that everybody understands the various paths that you can take under the court's instructions. And we prepared for you a little flow chart here, which hopefully will be helpful in explaining what the various options here that we're dealing with. And as Ms. Bozanich told you, we start up here with the charge of 187 PC is 187 of the Penal Code. And that's the Penal Code section which defines the crime of murder. And Lyle Menendez in this case is charged with murder with special circumstances. And special circumstances, as you learn at the very beginning of the case, are the thing which distinguishes first-degree murder from a special kind of murder, which ultimately could lead us down here, which is in a second trial where you'd be asked to decide the question of penalty. And at that stage of the proceedings, your only options would be death on the one hand or life imprisonment without possibility of parole on the other. That is the importance, the significance of the special circumstance allegations in this case. And Ms. Bozanich talked about checking off the multiple murder special circumstances if that was an unimportant decision. It's a very important decision because of where it can lead you in the decision flow here. So I ask you to keep in mind that the charges here are not just murder, but murder with special circumstances. And in this case, there are two. The two special circumstances are multiple murder and murder while lying in wait. And I'll get back to what those two terms mean in the law. But for now, we start up here with those charges. Those are the charges that you're faced with when you go back into the jury room. So you have the charges, and the first decision you're going to be asked to make, or one way in which you can decide to go about your deliberations in this case, would be to decide, well, is Lyle Menendez guilty or not guilty of murder? Just the question of murder. And I'm going to talk to you in a minute about what murder means. But the first decision you would make is guilty or not guilty of murder. If you were to decide that he is guilty of murder, then the question would become, what kind of murder is he guilty of? Your options would be two. He could be guilty of first-degree murder or second-degree murder. If you decided that he was guilty of second-degree murder, your decision would end here, and you would then go back to the second charge of murder, because each charge here, you'd have to follow the same course. So if you went through as to one charge, for instance, the charge of murder against Jose Menendez, and you decided, well, he's guilty of murder, but we think it's murder in the second degree, your decision as to that charge, that is murder against Jose Menendez, would end right here. You wouldn't go any further, and there'd be no need to reach the decision down here on the question of penalty. But you'd still have a second murder charge, and you'd go back and decide that in the same way. That is it murder? Is he guilty or not guilty of murder? If he was guilty of murder, is it first or second? If it was second, you'd end there, and that would be the end of the trial. You'd still have to decide conspiracy charges, which I'll discuss later. But as far as the murder charges would be concerned, you would end your decision-making there. There'd be no need for further decision. If, on the other hand, you decided as to the murder charge on Jose Menendez not guilty, that you didn't think murder was committed here in any degree, then you would find not guilty, but you would still have a second decision to make. And the second decision would be, okay, he's not guilty of murder. Is he nevertheless guilty of what the court will tell you is a lesser included offense, that is manslaughter? So you'd have to decide, is he guilty or not guilty of manslaughter? And if you decided not guilty manslaughter, you'll be provided a verdict form for that. And by the same token, if you decided he was guilty of manslaughter, your decision-making would end here. And you would then go back to determine the second count in the same way, and you could end up in the same box with the second count of murder. It's only if you decide that, number one, he is guilty of murder, and number two, it is murder in the first degree, do you get to this decision, which is the special circumstance charged in this case true or not true? Now, if you decided that Lyle Menendez was guilty, and he was guilty of murder in the first degree, you'd have to decide whether the special circumstances were true in this case. If you found that they were not true, the case would end there as to that charge. You'd go back up and use the same decision-making for the second count. And again, if you found it not true, you'd end up here and the case would end. And if, but only if, you found that charge true, in other words, you would have found that he's guilty of murder, that murder is in the first degree, and the special circumstance is true, would we have a second trial? And it would be at that stage you'd hear some additional evidence, and your options would be limited at that point to life imprisonment or death. And I think it's important to understand that it's something that we discussed months ago when you were first brought in as jurors, and you may have been wondering how this all plays out in terms of will we have a second trial or not have a second trial. This is the only way you could have a second trial, is if you made all these decisions as to both counts. Now, as you go through the flow chart making these decisions, is he guilty or not guilty of murder? And if you found him, Lyle Menendez, not guilty of murder, is he guilty or not guilty of manslaughter? There is an overriding principle that we operate under in our system. And you're going to see it expressed in various ways throughout the instructions. And one of the ways you'll see it expressed is with this instruction, which says, two instructions actually on one page here. It says, if you are convinced beyond a reasonable doubt that the crime of murder has been committed by a defendant, but you have a reasonable doubt whether such murder was of the first or the second degree, you must give the defendant the benefit of that doubt and return a verdict fixing the murder as of the second degree. So that applies to this decision. When you're deciding guilty or not guilty of murder, if you decide he is guilty of murder and you say to yourself, well, I have a doubt as to whether it's the first or second degree, it's your responsibility under the court's instructions to give the benefit of the doubt to Lyle Menendez and find that it's murder in the second degree, and the case would stop as to that count right here. And by the same token, if you found unanimously he is not guilty of murder, and then you went on to decide the question of guilty or not guilty of manslaughter, the court will tell you, if you're satisfied beyond a reasonable doubt that the killing was unlawful, but you have a reasonable doubt whether the crime is murder or manslaughter, you must give the defendant the benefit of such doubt and find it to be manslaughter rather than murder. So if you get to this point in your deliberations where you've said, we don't think it's been proven beyond a reasonable doubt that he's guilty of murder, can't really tell if it's murder or manslaughter, it's your obligation under the court's instructions to give him the benefit of the doubt and find that it's murder and find that it's manslaughter as opposed to murder. Now, reasonable doubt is a principle that's also going to be defined for you by the instructions. And it's probably, from our standpoint, from the defense's standpoint, the most important instruction that you're going to be receiving from the court, because it defines for you what the standard is for your decision. It's not a question, as you might have suspected from Ms. Bozanich's closing argument, of, well, which side do you favor the most? Who's telling the truth here? Choose between the two. No. You'll see from this instruction There's actually three concepts contained in this instruction. A defendant, and the three ideas in here are the presumption of innocence, proof beyond a reasonable doubt, and the definition of what reasonable doubt is. A defendant in a criminal action is presumed to be innocent until the contrary is proved. And in case of a reasonable doubt whether his guilt is satisfactorily shown, he is entitled to a verdict of not guilty. This presumption places upon the people the burden of proving his guilt beyond a reasonable doubt. And then the second part of this instruction tells you what reasonable doubt is. And it tells you that reasonable doubt is not a mere possible doubt, because everything relating to human affairs and depending on moral evidence is open to some possible or imaginary doubt. It is that state of the case which, after the entire comparison and consideration of all the evidence, leaves the minds of the jurors in that condition that they cannot say they feel an abiding conviction to a moral certainty of the truth of the charges, or the truth of the charge. And there are a couple things about that definition I'd like to point out to you. One is, you'll see here that it's after the entire comparison and consideration of all the evidence. And when Ms. Bozanich stands in front of you and says, you really only need to look at this bloody photograph to decide the case, that's contrary to the instructions. Because this instruction indicates to you that you're to decide this case not based on one bloody photograph or not based on the testimony of one witness, but the consideration of all of the evidence. And it's only after considering all the evidence that you can decide whether the charges have been proven beyond a reasonable doubt and to a moral certainty, which is defined in this instruction. And I think the essence of this instruction is you have to feel, each and every one of you, because the court's going to tell you that each side in the case is entitled to the individual opinion of each of you. And what that means is no one can be convicted in this courtroom unless all 12 of you agree that the case has been proven beyond a reasonable doubt. And under our system, it's not the majority rules. We're entitled to your individual judgment. And if you feel, based on a consideration of all the evidence, that a charge has not been proven beyond a reasonable doubt, it's your responsibility under the instructions to hold to that view, if that's your view after considering all the evidence, and not cave in to someone else because a majority of people may disagree with you. The court's going to tell you that each side has and is entitled to the individual opinion of each of you. And each of you have to be able to say that you have, when you come out of this jury room and reach a verdict, that each of you have an abiding conviction to a moral certainty of the truth of the charge. To me, the word abiding means lasting. Long-term lasting belief or conviction. It's not a suspicion. It's an abiding conviction is something which months from now you're going to be able to wake up in the middle of the night and think of this case and say to yourself, I did the right thing there because I had an abiding conviction in my decision. I believe beyond a reasonable doubt in the truth of those charges. It's something that I know is going to stick with me. And if you don't get to that state of mind, then under the court's instructions, you aren't entitled to find Lyle Menendez guilty of any charge. A way of thinking about reasonable doubt is in terms of various states of mind you might reach after listening to the evidence in the case. And you'll see along the left side of this chart, I have listed various conclusions that you might come to after listening to the evidence in this case. You might be saying to yourself, well, it might be that Lyle Menendez had the state of mind which is necessary for first-degree murder. And as I said in the first sentence of my argument, the question here is, did he have the state of mind that's required here? Not whether he killed his parents, because there's no dispute about that. The question here is his state of mind, as I'll explain to you later. You might listen to all the evidence in the case, hear the arguments of the lawyers, and say, I think Lyle Menendez might be, maybe guilty. And as you move up this sign, this side of the chart, you'll see your suspicions growing. From he might be guilty, he possibly could be guilty, I have a suspicion he's guilty. It's likely he's guilty, probably he's guilty, all the way up to here. A strong suspicion that he had the state of mind that's required for murder or manslaughter or whatever. all of those states in line under the court's instructions lead you to not guilty verdicts. And it's only if you get beyond this stage, beyond a reasonable doubt, abiding conviction, moral certainty, that you can say anyone is guilty of any criminal charge, whether it leads to the death penalty or not. That's the way our system works. How important are those concepts in our system? You probably don't recall this, but back in July, you were required to fill out this lengthy jury questionnaire. It was hundreds of questions, and we apologize for that, but it was necessary so that we got to know you in a very short period of time, and it was the only way under the law that we had of doing that. And in those jury questions, which both sides were provided and they used as a basis of evaluating whether you should serve in this case or not, there were two questions asked everyone on this jury panel. The first question we asked you, or one of the questions we asked you, was whether you agreed or disagreed that regardless of what the law says, a defendant in a criminal case should be required to prove his or her innocence. And everybody who's sitting on this jury said that they strongly disagreed with that statement. They strongly disagreed that the defendant should be required to prove his innocence. And the second question we asked you was whether the criminal justice system makes it too hard for prosecutors to convict people accused of crime. And we asked you to comment on that. And I think that your comments as a group probably speak more eloquently than any lawyer could ever speak on how highly we value the concepts of presumption of innocence and proof beyond a reasonable doubt. These are some of the things you said. The Constitution is for all Americans, innocent until proven guilty. The system is set up to protect the innocent and convict the guilty, who sometimes enter the system together. The process must be hard enough to separate the guilty from the innocent, yet fair enough to be just to all it serves. Another person wrote, I believe that it should be hard to convict people accused of crimes to protect the innocent. Someone else wrote, sometimes in the past it has seemed too hard for police and prosecutors to convict, but that is perhaps why our country is the best in the world. I cannot agree to disregard what the law says. We go by innocent until proven guilty. I feel it is the best system I have heard of. I agree that a person is innocent until proven guilty. Defendant is in a tough position already. And if the defendant has to prove his or her innocence, then there is already a negative tag of guilty on the defendant. I think our system works fairly well, and it's the best system there is. It is our basic right to innocence until proven guilty. Defendant is innocent until proven guilty. It is not easy and should not be easy. And lastly, I think the accuser should prove the accusation. And that's a very good, succinct way of saying the way our system operates. The accuser, in this case the prosecution, should prove the accusation. And this is how strongly this particular group feels about the principles of law I've been discussing with you. And we really took your word for it when you wrote those words down, and we trusted that you were going to abide by what you wrote there in terms of saying that you're going to hold the prosecutor to that burden of proof beyond a reasonable doubt and to a moral certainty. So there's no question in this case that the burden of proof is on the prosecution to prove beyond a reasonable doubt the truth of the charges in this case. And what is it exactly that they must prove? Ms. Bozanich went over it in a little bit of detail, and I want to give you again an overview of what I think it is that's at issue in this case. We start, as we did up on the flow chart, with the charge of murder. And I'm going to be discussing primarily the charge of murder here because, as you'll see under the court's instructions, the conspiracy charge will depend on whether you find, first of all, that there's an agreement. There has to be proof of an agreement. And I have yet to hear from the prosecutor when that agreement was formed or what the agreement entailed. But there must be an agreement, and it must be an agreement to commit murder. Two elements of conspiracy. And the court will instruct you that in order to find an agreement, a conspiracy to commit murder, you must find that Lyle Menendez had the same intent that he would have to have for the charge of murder. So really the charge of, and the same with conspiracy to commit manslaughter, you're going to learn that under the court's instructions, that the charge of conspiracy and the charge of murder really involve the same issues. And it's the case in this particular instance that by resolving the charges of murder, you will also see the way to go on the charges of conspiracy. So it's really the murder charges that I'm going to focus on here, and I'll explain to you a little bit more on the conspiracy charges later. But the basic charge of murder in this case is, and the definition of murder was given to you by Ms. Bozanich, there are three elements which she must prove. And under the court's instructions, as we go through these crimes, there are certain elements or parts to each crime I'm going to be discussing. The prosecution's required to prove all the elements. She can't get by with proving 2 out of 3. She can't say, well, I showed you that a human being was killed, and I showed you that the killing was unlawful, and there's a little bit of doubt on the malice aforethought part of it, but 2 out of 3 is not bad, so I win. No, it doesn't work that way. She only wins if she can prove beyond a reasonable doubt and to a moral certainty that each element of whatever charge is being discussed, be it murder or manslaughter, is proved beyond a reasonable doubt. So the 3 elements of murder are at the top of this chart, and there's actually a 4th, which is the defendant was the person who committed the murder. That is not a contested issue in this case. As I indicated to you, it is a contested issue as to whether it's murder, but it is not a contested issue that Lyle Menendez was the person who killed his parents. That's a homicide. The question is whether it's a murder or something else. So the 3 elements that are here that I'm going to focus on are a human being was killed, of course, that's not being contested. The killing was unlawful, and it was done with malice aforethought. And the 3rd element is the element that is really at the heart of the contest between the prosecution and defense in this case. And the court is going to define for you what malice is, and the court will tell you that malice is express. And this is a funny definition because the court will not tell you what it is. The court does not say, here's what malice is. This is the way the instruction reads. It says malice is expressed when there is manifested an intention unlawfully to kill a human being. There's also going to be a second kind of malice that the court's going to tell you about, and that's something called implied malice. It's not listed on this chart, but another way that you can find malice is implied malice. And implied malice usually applies to a situation where someone does not have an express intent, has not manifested an express intent to kill someone, but he does some act that is so highly dangerous that it's the same under the law as having an intent to unlawfully kill somebody. An example that's usually given is someone comes into a crowd of people with a bomb or a hand grenade and says, gee, I don't know anybody in the audience out here, but I think I'm going to throw this lighted hand grenade into the audience. Well, that person may not intend to kill any one particular person, but the act of throwing a hand grenade into a crowded room is so dangerous that the law in those circumstances equates that act with an intentional killing. And that would be an example of implied malice. What I'm going to focus on in the instructions, because I think it simplifies it, is the concept of express malice. And express malice is manifested when there's an intent unlawfully to kill a human being. You'll see under the court's instructions that intent to kill is also an element of manslaughter. And the court's going to tell you about the difference between murder and manslaughter, and you'll see that voluntary manslaughter is an unlawful killing where there is an intent to kill, but no malice aforethought. And involuntary manslaughter is an unlawful killing where there's no intent to kill. And murder is an unlawful killing where there is express malice aforethought. And express malice aforethought occurs when you have an intent to kill and there's nothing else which reduces that intent to kill to manslaughter. Once you've found that malice is present, once you've said that there is, in this evidence, proof beyond a reasonable doubt that the defendant intended unlawfully to kill a human being, and it is not second degree, and it is not self-defense or unreasonable self-defense, I should say, and it's not sudden quarrel or heat of passion. If you find that there's express malice, then under the decision tree that we started with here, you would have to decide whether it's murder in the first degree. And murder in the first degree has various elements or parts, just like murder. To get it beyond murder and into the category of murder in the first degree, the prosecution must prove certain things. And as Ms. Bozanich said, the instruction on first degree murder is lengthy, fairly complicated, but it's important that you understand it, because her approach was to say, well, you all have some idea in your mind about what a first degree murder is, but our own ideas of what a first degree murder are, or what they should be, may differ with what the law says a first degree murder is. And you might say to yourself, well, what difference does it make? The victim of a manslaughter is just as dead as the victim of a first degree murder. And so why should the jury be concerned with these fine legal distinctions between first degree murder, second degree murder, manslaughter? I think the answer to that is that the law recognizes that, as the prosecutor said in her closing argument, people are just human. They have certain human frailties, and an intent to kill someone that's formed under extenuating circumstances, although it may be unlawful and therefore an act of manslaughter, is not in the same category as a willful, deliberate, premeditated murder. And by the same token, a willful, premeditated, deliberate murder is not in the same category as a second degree murder, which is a murder where you have an intent to kill, but no evidence that it's deliberate, premeditated, and so forth. So the law makes these distinctions in recognition of the fact that people are not equally culpable, and that all unlawful killings are not the same. Some unlawful killings are more culpable, more blameworthy than others, and that's why these distinctions are important. That's why it's important that you understand what the distinctions are in this case, even though it gets somewhat technical. First degree murder is, and there's a typo up here, but all three of these elements must be proven to get first degree murder. Prosecution must prove, in order to get a conviction for first degree murder, that the murder was willful, deliberate, and premeditated with express malice aforethought. That's what first degree murder is. And the word willful, as used in the instructions, means intentional. The word deliberate means formed at or determined upon as a result of careful thought and weighing of considerations for and against the proposed course of action. The word premeditated means considered beforehand. And then the instruction goes on to tell you the circumstances under which first degree murder would be present. If you find that the killing was preceded and accompanied by a clear, deliberate intent on the part of the defendant to kill, which was a result of deliberation and premeditation, so that it must have been formed upon pre-existing reflection and not upon a sudden heat of passion or other condition precluding the idea of deliberation, it is murder of the first degree. The law does not undertake to measure in units of time the length of the period during which the thought must be pondered before it can ripen into an intent to kill, which is truly deliberate and premeditated. The time will vary with different individuals and under varying circumstances. And then it goes on to say, the true test is not the duration of time, but rather the extent of the reflection. A cold, calculated judgment and decision may be arrived at in a short period of time, but a mere unconsidered and rash impulse, even though it includes an intent to kill, is not such deliberation and premeditation as will fix an unlawful killing at murder in the first degree. To constitute a deliberate and premeditated killing, the slayer must weigh and consider the question of killing and the reasons for and against such a choice, and having in mind the consequences, he decides to and does kill. So, under the instructions, in order for it to be first-degree murder, you must find that it's deliberate, that is careful thought and weighing for and against the decision to kill. You must find that it's premeditated, that is, that the thought is considered beforehand. And you must find that it was committed with express malice aforethought, that is, that it was committed with an intent unlawfully to kill a human being. And in order for the murder to be of the first degree, you must find that the killing was by a clear, deliberate intent to kill formed upon a pre-existing reflection. No sudden heat of passion or other condition. If there is a sudden heat of passion or other conditions such as we'll discuss down here, unreasonable self-defense, which precludes the idea that someone was carefully weighing the considerations for and against death, then it's not murder in the first degree. It would be, in those circumstances, murder in the second degree, unless it was something less than murder in the second degree under the instructions which I'm going to talk about now. So in this case, if you were to say, after considering all of the evidence, if you were to choose that path in the chart that I began with, which says, I think that this case was murder, I think that murder was committed here because there was express malice, an intent unlawfully to kill a human being, but I don't think there was the careful thought and weighing for and against the killing, and I don't think it was premeditated, then the most it would be is murder in the second degree, because that would be a murder where you have express malice aforethought, but the evidence in your mind is insufficient to establish premeditation and deliberation. If you got to that point, then you would have to decide the question of, if you got to the point where you thought it was neither, that is, you didn't think it was murder in the first degree because there was no deliberation and premeditation, and you said to yourself, I have to then consider the question of whether it is murder or manslaughter, then you would get to the next instruction, which tells you about the distinction between murder and manslaughter. And again, I realize this is incredibly tedious, but it's the only way we have of explaining to you in a crash course what the law is so that you can intelligently decide this case. So the distinction between murder and manslaughter, as I mentioned a moment ago, murder requires malice, manslaughter does not. When the act causing the death, though unlawful, is done in the heat of passion, or is excited by a sudden quarrel such as amounts to adequate provocation, or in the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury, the offense is manslaughter. In such a case, even if an intent to kill exists, the law is that malice, which is an essential element of murder, is absent. And it goes on to say, to establish that a killing is murder and not manslaughter, the burden is on the people to prove beyond a reasonable doubt each of the elements of murder, and that the act which caused the death was not done in the heat of passion or upon a sudden quarrel or in the honest, even though unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury. So you'll see under that instruction that when you're deciding what distinguishes or what reduces murder to manslaughter, you basically have two options. First of all, you have the option of self-defense. And under the law, if someone actually and reasonably believes that it's necessary to defend themselves because they honestly and reasonably believe that they're about to be killed or they're about to suffer great bodily injury, that person is not guilty of any crime. That would lead to an acquittal. In this case, you're going to be given instructions about a different kind of self-defense, and it's a self-defense which is called imperfect self-defense. Imperfect self-defense is where you have an actual, the person really actually believes, but he unreasonably believes that it's necessary to defend himself. And in that situation, the crime is manslaughter. It's voluntary manslaughter if there is an intent to kill. It would be involuntary manslaughter if you were acting unreasonably and you didn't have an intent to kill. An example of that would be, at various points in the testimony, Lyle Menendez was asked, "What were you thinking when you put the gun against your mother's cheek?" And he responded, on several occasions, "I wasn't thinking. I was acting in a panic state. I was acting automatically." And Dr. Burgess attempted to explain to you what happens when the emotion of fear takes over in someone who has been abused, and that you, in those circumstances, the research is showing, go into an automatic state where you are not thinking. It is not a conscious thinking process on your part. You are merely responding, and your body is acting automatically. And you recall her testimony in that regard, and she was asked, this is a question from the transcript, let's talk about it in terms of fight or flight. Let's say somebody is coming at me to attack me. Their arm is raised, looks really angry. Now I've got to decide, my body's got to decide whether to fight him or to run. Now, what is going on biologically in this second stage when I'm being faced by this attack? She says, well, that's essentially when all of the hormones are spreading to tell the body to pick up two of these decisions of what you're going to do, make a decision. It generally is automatic because people begin to use, they are not even going to think because it's instinctual. The fear response is present in the body to protect the person from danger. So survival becomes the main goal, if you will, or why this whole system gets activated. So it is a physiological response to fear, and it is an instinctual response. You're not consciously thinking during this process, and she indicated that someone who had been abused was more likely to have that sort of an instinctive physiological response. And that is one way in which the evidence concerning the abuse history is relevant to your decision here. It's not relevant to make someone look like a bad guy and therefore to try and encourage you to reach a decision that because Jose Menendez was a bad guy, we're encouraging you to adopt some theory of vigilantism here. The evidence was offered properly because one of the decisions you're going to have to make is, was Lyle Menendez acting intentionally or was he acting instinctively during this time period, during the final week, when his fear response and the reaction to what was going on with his parents was combined with his history of abuse. And one of the ways in which you would find that the killing here, although unlawful, was involuntary manslaughter would be if you decided that as a result of considering all the evidence, you believe that Lyle Menendez actually, but unreasonably believed that it was necessary to defend himself, and you further believe that he wasn't thinking, was not consciously intending to kill anyone, and in those circumstances the verdict would be involuntary manslaughter because there is no intent to kill, although that killing is still unlawful. You will see when you look at the instruction on unreasonable self-defense, imperfect self-defense, a couple of things. A person who kills another person in the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury kills unlawfully, but does not harbor malice aforethought and is not guilty of murder. This would be so even though a reasonable person in the same situation, seen and knowing the same facts, would not have had the same belief. Such an honest but unreasonable belief is not a defense to the crime of voluntary manslaughter. It's also not a defense to the crime of involuntary manslaughter. And you'll see by this instruction that the belief can be unreasonable and that the crime is nevertheless manslaughter and not murder, even though a reasonable person in the same situation and seeing and knowing the same facts would not have had the same belief. So when Ms. Bozanich says to you, well, if we had known Jose Menendez was a child molester, we certainly would have prosecuted him. That really is missing the boat by a wide mark here, because the question is, first of all, Lyle Menendez had no idea who Ms. Bozanich was or what the practices of her office were or what the options were in terms of prosecution. The question is, what did the person even though you as reasonable people in the same situation, seeing and knowing the same facts, would not have had the same belief, you have to put yourselves in the shoes of Lyle Menendez and say, well, we have to view this from his perspective, his situation, in order to decide whether he actually had a belief in the necessity to defend himself against the threat of life or great bodily injury posed by his parents. And so to do that, you have to say to yourself not what you as reasonable people would consider to be the right thing in those circumstances, but if you were in that situation with the history of abuse that Lyle Menendez had, was there something about his situation and his life history which actually caused him to have that belief? And if there was, then he's only guilty of manslaughter. Voluntary manslaughter if you found an intent to kill, and involuntary manslaughter if you found there was something less than an intent to kill. And again, the prosecutor harped on the fact that we attempted to show that Jose Menendez was an abuser here. And we did produce evidence in that regard as to both parents. The court will instruct you that that was properly received in this case. And the court's going to give you an instruction which reads, evidence has been received in this case which may tend to show the character of the alleged victims for violent or otherwise abusive behavior. It may be reasoned that a person of such character for violent or abusive behavior would be more likely to act violently or abusively on any given occasion. However, evidence of such character for violent or abusive behavior may be refuted or rebutted by contrary evidence. Any conflict in the evidence of the alleged victim's character for violent or abusive behavior and the weight to be given to such evidence is for the jury to decide. And then the court's also going to instruct you. One who has received threats against his life or person made by another is justified in acting more quickly and taking harsher measures for his own protection in the event of an assault, either actual or threatened, than would be the person who would not receive such threats. If, in this case, you believe that one or both of the deceased made prior threats against the defendant, and that the defendant, because of such threats, feared greater peril in the event of an altercation with one or both of them, you are to consider such facts in determining whether the defendant acted in the honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury. Now, what does that mean? That means that we're not just throwing dirt at Jose and Kitty Menendez in this case. The evidence was produced for you because under the court's instructions, you are obligated to look at Lyle Menendez's situation from his perspective and to say to yourself, well, if I was in his situation, if I had lived with these people, if I had suffered the kinds of abuse that he testified to that was corroborated by other witnesses, would I have some actual fear that my parents were about to harm me when I told them that I was going to disclose that he was a child abuser? And the parents, after that threat by Lyle was made of disclosure, then went through a series of acts, and those acts led to an actual belief by Lyle Menendez that his life was in danger. You have to be able, under the court's instruction, to put yourself in his shoes and to say to yourself, I can't look at this from the perspective of the reasonable person who didn't have that history. I have to be able to say, under these instructions, that he did not honestly believe that he was in danger. And the fact that the parents abused him and his brother in the past, the fact that they witnessed abuse in the past, the fact that they heard threats to kill other people is relevant in this case because it shows that Lyle Menendez had an actual, although you may decide, unreasonable belief that he was about to be killed by his parents. And the standard here is not whether a reasonable person would have done something else, like fled the house. All that questioning on cross-examination about why didn't you run away is really designed to address the question of whether it's an actual and reasonable belief, but it does not in any way address the question of whether he actually believed his life was in danger. And so you take into account the history of abuse in deciding whether he actually believed that certain things his parents did caused him to fear for his life. And that's why that evidence was produced. And you'll see under the instructions that I just read to you that the grounds for fear do not require actual danger, but only the honest belief of peril, and that the burden is on the prosecutor to prove beyond a reasonable doubt that self-defense was not justified, and that if a reasonable doubt exists, the defendant is entitled to the benefit of that doubt. And under those circumstances, you would be obligated to find that the most serious crime that was committed here was voluntary or involuntary manslaughter. A second way in which murder is reduced to manslaughter is sudden quarrel or heat of passion. And there will be a series of instructions about sudden quarrel and heat of passion. And you'll see under the instructions that there is identified the kind of passion that we're talking about that will reduce murder from manslaughter. Neither fear, revenge, nor the emotion induced by an accompanying or following an intent to commit a felony, nor any or all of these emotional states in and of themselves constitute the heat of passion referred to in the law of manslaughter. Any or all of such emotions may be involved in a heat of passion that causes judgment to give way to impulse and rashness. Also, any one or more of them may exist in the mind of a person who acts deliberately and from choice, rather whether such choice is reasonable or unreasonable. The interesting thing about this instruction is it talks about, first of all, the emotion of fear as being the basis for a heat of passion defense. And in this case, it is the defense's contention that the evidence in this case shows that the defendants, Lyle and Eric Menendez, were acting out of fear. And in that sense, the heat of passion doctrine is very similar to the self-defense principles that we just talked about. When you are relying on fear as a emotion under heat of passion, fear is very similar to the fear of death or great bodily injury. You'll see under the court's instructions that fear can serve as a basis for heat of passion, but so can other emotions. And interestingly, revenge is mentioned. And even more amazingly, the emotion induced by an accompanying or following an intent to commit a felony. So apparently someone can go into a liquor store and be excited about committing a robbery, and in the emotion of committing that felony, someone is shot. That killing could be, under this instruction, a heat of passion under certain circumstances, because the excitement of the moment is something that is taking over and controlling that person's emotions. And even though the person is acting unlawfully, his intent to kill is formed as a result of the heat of passion accompanying or following an intent to commit a felony. And under the law, that person could be guilty of manslaughter. Here, of course, you have a much less, how should I say it, sinister emotion, and the much less sinister emotion is the emotion of fear. But it's interesting, I think, because the prosecutor is claiming that the brothers acted out of, I'm not sure what she's claiming, because there's been so many theories advanced as to motive, I can't keep them all straight. She originally began during her opening statement talking about money, financial gain, and there was also some talk about committing the perfect murder. And in the closing argument, we're now talking about camcorders and the desire to be free of the parents' control. So the issue of what motive is involved in these killings is not altogether clear. But under the people's main theory, the theory that they tried to advance throughout the case, the brothers were killing out of the desire to be freed of their parents' control. And there were questions asked on cross-examination along the lines of, isn't it true that you killed your parents because you were fed up with the abuse that was being inflicted upon you? Even under the prosecution's version of facts, if you were to decide, yeah, I think that's what the motive here was, that these brothers were killing out of being fed up with being abused and the control that their parents were exercising over them. Even under that interpretation, which we say is totally wrong, you could have voluntary or involuntary manslaughter because it would involve the emotion of revenge. Either fear, revenge, or emotion induced by a company. And it goes on to say, any or all of such emotions may be involved in heat of passion. So even under the prosecution's version of the case, you can have voluntary or an involuntary manslaughter. There are several other principles about heat of passion that are important for you to understand. One of them is the court's going to instruct you that the passion necessary to constitute heat of passion need not mean rage or anger, but may be any emotion, including fear, which causes a person to act rashly and without deliberation and reflection. No specific type of provocation is required to generate the passion necessary to constitute heat of passion, and verbal provocation may be sufficient. If someone verbally provokes you, and as a result of that verbal provocation, you decide to kill that person, and you do it under circumstances where you don't have time to cool down, then that can be manslaughter, even though you kill that person unlawfully and you do it with an intent to kill. The court's going to give you some instructions on cooling period. And cooling period typically arises in a situation where the emotion being relied on is anger. If someone is angry at somebody else, that anger over time subsides. And the law says that if there's sufficient cooling period between whatever it is that provokes you and the time that you kill that person, then it would not be a proper charge to convict someone of manslaughter, because you've had time to regroup and to get back your presence of mind. And as I say, typically that instruction applies in a situation where you have anger as the emotion. Somebody verbally provokes you, calls you son of a bitch, you get very angry, but you go out for a walk. You can't 20 minutes later, after your anger has cooled down, come back and shoot the person. That wouldn't be right, and that's murder, not manslaughter. But in this case, fear is a different kind of emotion, because fear, based on everything we know about it and experiencing it ourselves, is not the kind of emotion which typically cools down. In fact, it can grow over time. And so you have to keep that idea in mind when you consider this idea of cooling period, because cooling period does not work real well with some emotions, and fear is one of them. And the court's going to tell you that a defendant may act in the heat of passion at the time of the killings as a result of a series of events which occur over a considerable period of time. Now, what does that mean? Just like in the case of unreasonable self-defense, you can take into account the history between two people in deciding whether the person is acting in the heat of passion. If someone is your arch enemy and over a long period of time has consistently threatened or abused you, then it's more reasonable for you to act when that person threatens you again than it would be for someone who was just a stranger to you and you had no history with. That again is why the abusive conduct by the parents going way into the early years is relevant here. When Lyle Menendez talks to his father at age 13 about stopping the abuse of his brother, and the father says, "It'll stop, and this is just going to be our secret, and don't tell anybody or I'm going to kill you," that's something which plays later on into whether Lyle Menendez was acting in the heat of passion when his father made the same kind of comments about whether he was going to allow Lyle to go out and reveal the abuse secrets to the world. So again, you take into account the entire history, and those will be gone into in some detail by Ms. Lansing tomorrow. But it's important to realize again that abuse history and the evidence which you heard about the early relationship between the parents and the Menendez brothers is something which is properly before you so that you can decide whether these killings were committed in the heat of passion. So just to complete this chart, passion can be fear or any emotion that causes judgment to give way to impulse and rashness. No specific type of provocation is required. Verbal provocation may be sufficient. And it may be the result of a series of events which occur over a considerable amount of time. And again, the burden is on the prosecutor to prove beyond a reasonable doubt that the defendant did not act in the heat of passion. As you go through all of these decisions, you'll see that what you're primarily dealing with here is mental states of mind. That is, For murder, did the defendant kill unlawfully, and did he kill with express malice aforethought? For first-degree murder, did he kill deliberately and with premeditation? Second-degree murder, did he kill, if there was no premeditation and deliberation, did he kill with express malice aforethought? For manslaughter, did he kill with the actual but unreasonable belief in the necessity to defend himself? And for sudden quarrel, heat of passion, did he kill out of a heat of passion? Was his intent to kill formed as a result of a heat of passion? All of those decisions require you to look at the mental state of Lyle Menendez, and the court's going to tell you that a crime is only committed when there's a joint operation of act, in this case killing someone, and a certain mental state in the mind of the person. So it's Lyle Menendez's mental state at the time of the killings, which you have to look into and decide, was he acting with malice? Was he acting with deliberation, premeditation? Was he acting in a reasonable self-defense? Was he acting out of heat of passion? All those decisions have to do with mental state. And mental state is something, because it goes inside someone's mind, that cannot be proved directly. Someone can talk about their mental state, but mental state is something that must be proven by circumstantial evidence. And the court's going to tell you that there are basically two kinds of evidence. Direct evidence, that's where someone sees something. Lyle Menendez testifies, "I killed my parents." That is direct evidence. He was an eyewitness to the killings. Directly proves that he in fact did kill his parents. But his mental state at the time, he directly testifies to it, because he testified that he acted out of fear, out of panic. That's a direct proof of what his mental state is. But generally, you are relying on circumstantial evidence to prove mental state. And there are special rules which apply to circumstantial evidence, which I'd like to talk to you about just briefly. As I said, the court's going to instruct you that circumstantial evidence and direct evidence are the same, entitled to the same weight. But he's also going to give you a special instruction on circumstantial evidence. And the circumstantial evidence instruction says, however, a finding of guilt as to any crime may not be based on circumstantial evidence unless the proved circumstances are not only consistent with the theory that the defendant is guilty of the crime, but cannot be reconciled with any other rational conclusion. Further, each fact which is essential to complete a set of circumstances necessary to establish the defendant's guilt must be proved beyond a reasonable doubt. In other words, before an inference essential to establish guilt may be found to have been proved beyond a reasonable doubt, each fact or circumstance upon which such inference necessarily rests must be proved beyond a reasonable doubt. Also, if the circumstantial evidence as to any particular count is susceptible to two reasonable interpretations, one of which points to the defendant's guilt and the other to his innocence, you must adopt that interpretation which points to the defendant's innocence and reject that interpretation which points to his guilt. If, on the other hand, one interpretation of such evidence appears to you to be reasonable and the other interpretation to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. Jurors often get confused about that last sentence, and prosecutors often jump on this last sentence and say, oh, that means that if Lyle Menendez's interpretation of the evidence is unreasonable, you have to reject it and find him guilty. No, because the evidence is still subject to proof beyond a reasonable doubt. It's the prosecutor's burden under the other instructions that I read to you to prove beyond a reasonable doubt that Lyle Menendez is guilty. And so this is an instruction which is given in connection with the beyond a reasonable doubt instruction. And it tells you that if you reach that point in your deliberations where you think, well, it could be one of two things. Either he did have malice or he didn't. It's equally plausible as to each. There's evidence to support each. It's not his version is not unreasonable. Prosecution's version is reasonable as well. Under the instructions, it's your duty to find that the charge has not been proven. It would be your duty to find Lyle Menendez not guilty under those circumstances. And there's another instruction which applies circumstantial evidence, the rule that I just read to you, to mental state. The specific intent or mental state with which an act is done may be shown by the circumstances surrounding the commission of the act. However, you may not find the defendant guilty of the crimes charged or any lesser crimes unless the proved circumstances are not only consistent with the theory that the defendant had the required specific intent or mental state, but cannot be reconciled with any other rational conclusion. Also, if the evidence as to two such specific intent or mental state is susceptible of two reasonable interpretations, one of which points to the existence of the mental state and the other to the absence, you must adopt that interpretation which points to the absence of the specific intent or mental state. And then if, on the other hand, one interpretation appears reasonable, the other unreasonable, you must accept the reasonable, reject the unreasonable. This then is how you weigh circumstantial evidence which proves specific intent or mental state. And you'll see from this that the instruction directs you to look at the circumstances surrounding the commission of the act to decide what mental state was taking place at the time the act was committed. And that was one of the reasons why we presented the testimony of Ann Burgess, because her testimony was directed to the circumstances surrounding the act, and specifically the crime scene evidence, and what can be inferred from the crime scene evidence as to whether the person who committed whatever happened there that day was acting with deliberation or premeditation, was acting carefully after weighing the decisions for and against, or instead was acting out of fear, and do the circumstances of the crime scene point in one direction or the other. And you recall Dr. Burgess was a person who has been working with the FBI for 10 years as an expert on victims. And it's been her expertise, and her life has been devoted to helping law enforcement develop ways to better understand how to catch people who commit crimes by looking at the crime scene. When the prosecutor refers to her as a hired gun, I find that incredible in light of this person's background and training. This is a person who is affiliated with law enforcement. She's worked with the FBI, still works with the FBI, and she was the one who was responsible for the crime classification that the FBI uses to catch criminals. And yet she is painted as a hired gun along with every other expert in the case who you're supposed to just completely reject and not put any weight on whatsoever. And I think a fair judgment as to Dr. Burgess is that she's an incredibly qualified person. She's someone who offered testimony, I think in this case, which was helpful in analyzing the crime scene, as well as analyzing what the effects of fear are. And she's someone who is not subject, I don't think, to a fair charge that she's simply a person who would come into a court of law, take an oath to tell the truth, and lie because she was getting paid money. And that sort of broad-brushed attack on our defense witnesses, I think, needs to be carefully looked at by the jury, because I think it's an unfair attack, and I think it really attempts to minimize the importance of the expert testimony which was presented to you, and which, as you'll learn under the court's instructions, was properly presented to you. Sometimes experts can contribute something that we as common folk don't know about. And I don't know about you, but I have not spent a lot of time analyzing crime scenes or talking to serial killers or researching victimology as Dr. Burgess has, and I think she did have something to contribute to this case. She was asked her opinion of whether the crime scene in this case was an organized or a disorganized crime scene under the criteria used by the Federal Bureau of Investigation. And she said, the question was, and in applying these guidelines and analytical methods to the crime scene here, did you reach a conclusion about what kind of crime scene this was? Answer, yes, I did. And what was that? Answer, and I'll preface it, if there may be indicators of both organized and disorganized, but generally in this crime scene, I saw more evidence of disorganized organization. Question, and did that indicate to you a lack of planning to avoid detection? Answer, yes. Question, and does it appear to be a disorganized crime scene because you cannot see any significant evidence of planning to avoid detection? Answer, yes. Question, now, what under the FBI's criteria, what was disorganized about the crime scene? Answer, location, choice of weapon, injuries to the victim, emotionality, indicators of emotionality, and lack of staging. And she went on to explain how the use of the particular weapon, in this case a shotgun in a busy residential area, was an indicator to her as an expert and as an analyzer of crime scenes that this was not a real carefully thought out, well-planned, deliberate, premeditated scheme going on here, given the fact that this was numerous shotgun blasts shot off in the middle of a Beverly Hills neighborhood. And she also talked about injuries to both parents, and this goes to the coroner's testimony as well, describing the pattern of injuries that he described on both Mr. and Mrs. Menendez. Question, now you said the third factor leading to a characterization of disorganized was the injuries to the victims. And what do you mean by that? Injuries to victims is that you look at where on the body in a gun shooting case, where the injuries are, not only where they are on the body, but the number. And why does that tell you something about organization versus disorganization? Answer, more organized type of person who shoots is going to use the minimum amount of shots to accomplish the task. She then went on to describe emotionality and why that was an important consideration. And she said that the term emotionality is sometimes used overkill, that there is a large, more shots are fired than is necessary to accomplish the task. And that was a situation in this crime scene that a large number, far more shots were fired than were necessary. And she was asked, in this particular case, what analysis did you come up with concerning where the injuries were on these two decedents? She said, my analysis is that the injuries were random, if you will. They were to all parts of the body. There was not one area singled out. Question, what conclusion based on this analysis could you draw? Answer, well, that would speak to a more pervasive emotion than just one emotion, such as anger or rage or what, but would speak to a wider aspect. Questions such as, she says, such as fear. And then she went on to describe how the presence of the absence of shells and the presence of the absence of a weapon at the scene was an indication of an organized crime scene, but she pointed out that there was a difference in organization, post-crime planning, planning during the crime, and pre-crime planning. And you'll see under the court's instructions on first-degree murder that what the law is concerned about is pre-crime planning, because deliberate, premeditated murder is committed when someone before the murder carefully weighs and considers the question of killing, and after carefully weighing and considering the reasons for and against the killing, they go ahead and make the decision and kill. If after that decision is made and the person kills somebody and then does something else, then they're into the post-planning period, and it can be subject to two reasonable interpretations. For instance, if someone kills in the heat of passion, you kill someone because they've abused you and they've just made a remark to you which is threatening, and you go ahead and kill that person. You shoot them someplace where no one else is around, and you realize, I've just killed unlawfully. I know I just committed manslaughter. I don't really want to go to jail. I'm going to do something to hide this crime. You hide the gun, or you bury the body, or you leave the jurisdiction, or you take money from the person and you spend it. You have to be careful, because what you do after the crime may very well reflect on what your state of mind is days or minutes or months after the crime, but it doesn't necessarily tell you a whole lot about what you were thinking at the point in time when the trigger was pulled. And that's the point in time when the law focuses you on, because that's the point in time when, if a crime is committed, there has to be this union of act and mental state. So it's pre-crime planning that the law looks to. And Dr. Burgess attempted to analyze a crime scene in such a way that you would be able to look at it and say, what is there about this crime scene that points to deliberation, premeditation, or malice? Does it point to that, or does it point to something more in the nature of fear and heat of passion? Now, you may give the prosecution the benefit of the doubt and say, I think the crime scene points to premeditation and deliberation. That's one reasonable interpretation of the crime scene. You may also say it's equally reasonable that because of the way the crime scene looked and the circumstances of that crime scene, it's just as reasonable to infer fear and heat of passion from that crime scene. And under the court's instructions that I just reviewed with you, it would be your obligation to accept the interpretation which pointed toward innocence or to the lesser included offense and find Lyle Menendez not guilty. And that's an illustration of how circumstantial evidence is used in this case. I want to talk briefly, and I want to try and finish today, so I don't want to go too much longer. Briefly about the testimony of Dr. Oziel. How else do you prove that someone's mental state was what it was at a given period of time? You can do it through statements of the defendant. And the court's going to give you an instruction on what the law calls admissions or confessions. If someone says to someone else, I killed this guy and I did it with express malice aforethought, he's not going to use those words, but he may say, I did it with the intent because I wanted to kill that son of a bitch. And that witness comes in and testifies to that. That's a pretty good indicator of what that person's mental state is, if two things can happen. Number one, in that situation where some person's coming in saying, this other person made a statement to me, the question for you as jurors to decide is, number one, was the statement made? Did the person hear it correctly? Is that person honestly reporting to us what was said by the other person? And then the second question is, if the statement is being accurately related to you, is the person who's doing the speaking truly as to what their intentions are? Because if the person is not speaking truly as to what their intentions are, then the statement is not a very good indicator as to what the person's mental state was at the time of the crime. And that type of analysis applies to the testimony of Dr. Oziel in this case. The prosecutor attempted to deal in her closing argument with Dr. Oziel by saying, well, the defense is going to say he was our star witness, but really the only reason we called him was so that he was a witness that we had to call in order to prove that it was the defendant who was the killer, to prove the question of identity, not the question of motivation. And the only importance of Dr. Oziel was that he testified that Lyle Menendez admitted to the killing, and he had to be called because we had to prove as prosecutors beyond a reasonable doubt that he was the killer, even though the defense says that they conceded that that was the case. That's a very interesting way of dealing with Dr. Oziel, because when the case began, the prosecution went into his statements at length during her opening statement. And she went into him at length because she was relying on him at that point, before any evidence was offered, to try and show to you, to prove to you what Lyle Menendez's motivation was. And you recall from the opening statement that at the beginning of the case, she was claiming that the evidence would show that Lyle Menendez's motivation was that his brother was he and his brother were committing the perfect crime, and that was proved up by the testimony of Dr. Oziel. And she also indicated that the evidence would show that they did it out of hatred, out of greed, and various other motivations that she attributed to the killings, but they all centered on Dr. Oziel and what Dr. Oziel was supposedly going to testify to. As it happened, Dr. Oziel sort of disintegrated as the case progressed. So by the end of the case, there's really not a whole bunch left of his credibility, and I don't intend to spend a lot of time on it. You heard the evidence, and you heard all the evidence in regard to his credibility. I agree with Ms. Bozanich, this is not divorce court, but Dr. Oziel was offered to you, at least according to the opening statement, as a witness who was going to prove the motivation for these killings, and it became important to show whether he was telling the truth or not as to what he heard. And of course, if he heard what he says he heard, then that would put someone in fear. If someone comes in to you and says, yeah, we killed our parents and I'm going to kill you, Dr. Oziel, that would put somebody in fear, and you would expect someone who had received that kind of information to act like they were in fear. So we explored with you what Dr. Oziel's behavior was after he supposedly received that information, to see if in fact he was acting like a person who was in fear for his life or had been threatened. And all the testimony about his behavior went to show that Lyle Menendez's testimony about what he told Dr. Oziel is the more believable of the two witnesses here, because he denied ever threatening Dr. Oziel. He denied most of the outrageous statements that Dr. Oziel said were made to him. And Dr. Oziel supposedly said these statements were made to him after he had warned Lyle Menendez. Now remember, Lyle, if you threaten me, what you say to me is not confidential. And according to Dr. Oziel's version of it, it was after telling Lyle that he was not subject to confidentiality that Lyle Menendez went ahead and threatened Dr. Oziel, and not only threatened him, but supposedly, according to Dr. Oziel, signed on to a version of first-degree murder. Because you remember, according to Dr. Oziel's testimony, he offered him two options, which incredibly are almost verbatim the legal definitions which you are required to decide here. Review Dr. Oziel's testimony, and he's got Lyle Menendez faced with the choice of, Lyle, is this heat of passion or is this premeditated or deliberate killing? And according to Dr. Oziel, he signs on to the premeditation deliberation package. This is supposedly after Oziel tells him that what you tell me is not confidential. Well, if he had signed on to that version, would you expect Dr. Oziel to be acting the way he was acting in the days and months following receiving that information? And the tape recordings which were played for you during the testimony of Ms. Smith, and whatever you think about her credibility, the tape recordings have the voice of Dr. Oziel on them. They were offered to show that Dr. Oziel, first of all, lied to you about several things, and second of all, that he was not someone who was in fear of anybody during this period of time that he said he was in fear. So the first question with respect to Dr. Oziel is he testifying truthfully about what was said? And I think you have to look is who this man is. He is a psychologist, a certified sex therapist, who at the time he was counseling the Menendez brothers was on probation for having a dual relationship with his clients. And he was on probation from 1988 to 1991. He was on probation during the time that these conversations supposedly were overheard by him. And at the time he testified at trial, he was under accusation by the Attorney General's office for, again, dual relationships. So as he's sitting here testifying, you have to wonder what his motivation is for not telling you whether in fact he was attempting to somehow manipulate the brothers or manipulate other people for his own benefit. He's certainly not going to admit and therefore jeopardize his license, which is under question because of the present accusations, by saying that Miss Smith was his patient. And yet there's evidence in front of you that he's writing excuses for her for court that, based on one falsification of the excuses that he gave, that he was considered for prosecution by the same DA's office that's prosecuting this case, and the prosecution was rejected for statute of limitations problems, whatever those were. But I think you have to consider, is Dr. Oziel telling you the truth? What this man's motivations are, and is this a person who has his own agenda here to save his license? Did he have an agenda at the time these events he's testified to are taking place? Was he attempting to manipulate his girlfriend and his wife by using some information he had received from the Menendez brothers in order to control and manipulate these women? Is he the type of person that preys on people like Miss Smith, or preys on people who were in unfortunate circumstances? Was he attempting or in the process of following his MO of preying on people when he on his own contacted the Menendez brothers in the days following the murder, and when he later tells Miss Smith, "Get out of here, Judulon, there's $14 million involved in this"? What are his motivations? Is he a clean witness in this case? And I think the answer is clearly not. And I think in response to the answer being clearly not, the prosecution has to bail out of Dr. Oziel. He's no longer the star witness, because to make this case depend on Dr. Oziel's credibility is to make it depend on quicksand. So now the star witness becomes Perry Berman. And the reason it's explained to you that Perry Berman is the star witness is because he had a conversation with Jose Menendez, and Jose Menendez said he was going to help Perry Berman out. And since he said he was going to help Perry Berman out, doesn't that indicate that he was not contemplating killing Lyle Menendez? Well, the question here is not whether Jose Menendez was in fact plotting to kill Lyle Menendez. That's beside the point. The question here is, did Lyle Menendez actually believe, as a result of what he saw and what he heard and the history he had undergone with Kitty and Jose Menendez, did he actually believe he was in danger? So how Perry Berman and the woman from the sporting goods store all of a sudden become the star witness and Dr. Oziel is dropped from the spotlight, I think is apparent. It's an attempt to bail out of a very uncomfortable situation where the prosecution's star witness has turned into not so much of a star after all. The two other issues I wanted to discuss with you, and I know it's late. Briefly, the testimony of the coroner. The prosecutor asked or posited that we had not shown to you, we had not proven to you, as if it's our job to prove to you, which it's not, how Jose Menendez obtained the shot through the thigh. And she then speculated that she thought that the shot to the thigh took place when, if I understand it, he was already sitting down and the leg was somehow up and moving. The coroner testified that all of the, first of all, Miss Bozanich's arithmetic is a little off here. She gives a little benefit of the doubt as to Mrs. Menendez and says, well, let's assume there were 7 wounds. And as to Mr. Menendez, let's assume there were 5 wounds. And there were 2 shots through the door. That makes 14. We know the guns hold 6. Therefore, there must have been 2 shots on the reload. The problem with that arithmetic is that the coroner testified that the number of wounds does not mean that that corresponds with the number of shots. And the reason for that is that he indicated that some of the shots could have been what he talked about as pass-through shots. That is, some of the shots, and some of them were distant shots, where some of the load from the pellets could have gone in Mr. Menendez, some could have gone in Mrs. Menendez. He also testified that it was possible that there were pass-through shots, that some shots passed from one person to the next. So the fact that there are 7 wounds does not mean that there were 7 shots. The fact that there were 5 wounds on Mr. Menendez does not mean there were 5 separate shots. So the arithmetic doesn't quite work. But aside from that, the theory of the prosecution, as I understand it, is that he is somehow sitting down when the leg wound, the thigh wound, is inflicted. I don't think that's the way it could have happened, because the coroner said, and she also indicated that the wounds to the back of Mr. Menendez must have been inflicted when he was already seated down. I think the coroner was pretty clear in testifying that the wounds to the back of the elbows of Mr. Menendez could not have been inflicted looking at the photograph in the way in which he was seated down, because the arms are covered by the couch, and the only way that could have happened is if you shot through the couch. I think if you asked to have that portion of the coroner's testimony reread, if there's any doubt about that, and that's generally what we do if there's some question about the evidence, that you'll see that the coroner was very clear that the wounds could not have been inflicted to the back of the arm when he was on the couch. And I think he was also clear that the leg wound could not have been inflicted when he was seated in the position that he's shown in the photographs, because the leg wound to the thigh was a shot that went from the inside of his thigh to the outside of his thigh. And he indicated that since there were no pellets found inside the wound, that the shots would have been blown out the outside of the leg, and there would have been some sort of particle, blood or pellet particle, either on the couch or in the area immediately to the left, if he was seated in the position in which he is shown in the photographs when he received those injuries. And you'll see from the photographs there is no particle or any sort of markings to the left of Jose Menendez's leg, so it could not be that he was seated. By the same token, the coroner also testified that the wound to the leg probably would have been incapacitating. So one possibility here is Jose Menendez, as you recall from Lyle Menendez's testimony and also Eric Menendez's testimony, was moving toward him at the point in time when the doors were burst open. And one possibility here is he has his arms up in some way, and he is shot in the back, and the coroner said the fact that he's shot in the back does not mean somebody's standing behind him, because if someone is moving their arms in some way, the shot could come into the back, and yet the shooter could be facing you. One possibility here is Lyle Menendez shooting from the door area into the back of the hands. Eric Menendez, meanwhile, according to his testimony, is moving from the doors around to the area in front of the TV, and according to his testimony, is just firing, randomly firing. There are shots into the French doors, two random shots that go through the French doors. There is exhibit number 17 are the pellets which were recovered by the coroner, and you recall the firearms examiner said that there were for buckshot, there were, according to his analysis of the evidence that was found both in the coroner's examination and evidence found at the crime scene, he indicated that there were 6 shots, at least 8 shots fired, 6 shots of buckshot and 2 shots of birdshot. And he said that the buckshot that was used contains 27 pellets per round. And he was asked if 6 buckshot 6 loads of buckshot were fired with 27 pellets, would that mean 162 buckshot pellets and 6 rounds? He indicated that that would be the case. Only 56 of those pellets were recovered. I believe it's Exhibit 16 or 17. The actual pellets recovered by the coroner are in evidence. He indicated, I believe, that he did not recover all of the birdshot pellets. Some of those birdshot pellets were left in the bodies. But as to the buckshot, I believe he testified he recovered all the buckshot that he could. Maybe an error on that, but I think he said he recovered all the buckshot that he could from the bodies. And if you sat down and went through those envelopes, you would see that there are 56 pellets recovered, 56 individual buckshot slugs recovered. And if 6 shots were fired, that means 162 minus 56 did not hit the target. And we also know that there were 2 shots through the windows, which would indicate that there was some random shooting there by someone. And so one possible scenario here is Lyle Menendez shooting at a point in time when Jose Menendez is up and about, hits him in the back of the arms. At the same time, a shot coming in from the area of the TV from Eric Menendez through the left thigh, and the particle going out through the leg into the same area of the couch which is covered by blood. And if you look at the portion of the couch where Jose Menendez was seated, you'll see blood in that area where he was seated. The shot blows out into the back of the couch. The shot to the leg incapacitates him, and at the same time, Lyle Menendez is coming forward, and the last shot in time would be the shot which was the contact shot to the head, which he indicated took place very quickly after the first shot was fired. And the coroner also indicated that the sequence of these shots must have been very rapid. And he thought that the shots were very rapid because all of the wounds that he examined were anti-mortem wounds. And since some of the shots were fatal, the fact that there were no post-mortem wounds meant to him that all of these shots must have been fired in very quick succession. That testimony is also consistent with the testimony of the neighbors who heard firecracker-type sounds which were not interspersed by a great deal of space. So as to the defense not explaining exactly how this shot was inflicted to the leg, I think there is a reasonable interpretation of the evidence which would show how that shot was inflicted. And in any event, I don't think it's our burden to show how one shot or another was inflicted. The burden is on the prosecution. And then lastly, I wanted to talk briefly, because of the importance of the question, about the special circumstance allegation. And I hesitate to even talk about this because it's our very strong position in this case that based on the evidence that you've heard and based on proof beyond a reasonable doubt, that by the end of your deliberations, you should be on this side, the left-hand side of this decision tree, not on the right over here. But because of the obvious consequences of a finding of special circumstances in this case, I want to talk just briefly about the 2 special circumstance allegations and also the charge of conspiracy. And I'll talk about the conspiracy charge first. And the reason I said earlier that the conspiracy charge and the murder charges require you to decide the same things is because of an instruction the court is going to give you about the conspiracy charge. And first, the court's going to tell you that a conspiracy is an agreement entered into between 2 or more persons with a specific intent to agree to commit the public offense of murder or manslaughter, and with a further specific intent to commit murder or manslaughter, followed by an overt act committed in the state by one or more of the parties for the purpose of accomplishing the object of the agreement. It's a very hard definition to follow. But you may ask yourself, well, if someone meets with someone else, and again, I challenge the prosecution to point to when the agreement was formed in this case. When was there a meeting of the minds between Lyle and Eric Menendez where they got together, and the court's going to say she doesn't have to prove an express agreement, but still an agreement must be proved to show that a conspiracy exists here. When did the conspiracy get formed? When did they come together, and what was the object of the conspiracy? And I challenge her to pinpoint for you what the charges are so that you can decide whether that charge is true or not. You may ask yourself, well, how can somebody come together and agree to kill somebody and not have that be a premeditated killing? Because if you agreed with somebody else in advance that the killing was going to be premeditated, that you were going to kill somebody, wouldn't that be murder in the first degree? And the court's going to give you an instruction about that, which says the fact that a killing was planned in advance, whether individually or in concert, does not prove that the planner acted with malice or with premeditation and deliberation. If, as a result of heat of passion, sudden quarrel, or an honest but unreasonable belief in the necessity to defend against imminent peril to life or great bodily injury, a man kills without malice, he commits murder. It necessarily follows that if this same man, under those same circumstances, conspires to kill, he conspires to commit manslaughter. So you'll see under this instruction that this instruction requires you to go back to the evidence again and decide whether any agreement that did exist here, was that an agreement to kill which was formed as a result of heat of passion or the honest but unreasonable belief that someone was about to kill you. Because if two people think that they're about to be killed and they come together and say, you know, we're about to be killed, we got to do something about this, that may be a conspiracy. May not be, but it may be a conspiracy, but it's only a conspiracy to commit manslaughter, not a conspiracy to commit murder, because the agreement is formed upon the heat of passion or the unreasonable belief in the necessity to defend yourself. And then lastly, the special circumstances. As I indicate, if and only if you decided the charges were murder, and a charge was murder in the first degree, would you get to the decision of true or not true, the special circumstance. And the rules for special circumstances are exactly the same as for the charges. That is, they must be proved beyond a reasonable doubt and to a moral certainty. If they depend on circumstantial evidence, the same rule applies that if there are two reasonable interpretations, your duty is to adopt that interpretation which points toward innocence. And you'll see from the instructions that the exact same rules apply, obviously because of the consequences which follow a finding of true to the special circumstance allegation. Two special circumstance allegations that are charged in this case are multiple murder. And the court's going to tell you that to find the special circumstance referred to in these instructions as multiple murder convictions to be true, it must be proved that the defendant has, in this case, been convicted of at least one crime of murder of the first degree and one or more crimes of murder of the first or second degree. All right? Now, what that means is, suppose you looked at the evidence and you said, and I'm not suggesting you do this, I'm using this hypothetically because I want to illustrate the multiple murder special circumstance, but suppose you decided after viewing the evidence that Lyle Menendez was guilty of the manslaughter of Jose Menendez. And suppose, or he was guilty of second-degree murder of Jose Menendez. As to that charge, you would stop because you would not have found it first-degree murder. But suppose, just hypothetically, that you went back and you said, but I think as to Kitty Menendez that it's first-degree murder. If you found that, and again, I am not in any way suggesting that that's a proper verdict, I think it is not. But if you were to find that, then the question would be, is the special circumstance of multiple murder true? If you had found that the charge as to Jose Menendez was manslaughter, then the multiple murder special circumstance would not be true, because in order for it to be true, the second murder would have to be murder, first of all, and it would have to be in the second degree. And you could switch it around. Suppose you found that as to Kitty Menendez, Lyle Menendez was only guilty of manslaughter. As to Jose Menendez, he was guilty of first-degree murder. That would not, the multiple murder special circumstance would not apply there because you would need a second degree. It's only if you have a first degree and a second degree, or two first degrees, that you could find that the multiple murder special circumstance would be true. And I hope that that's clear. And that in turn goes back to the instructions that we've been talking about all afternoon. In order to find out whether it's first degree murder, you have to go through the analysis that I outlined in the charts. And it's only if you reach that point of finding one first degree and at least a second degree that you could find that the special circumstance would be true. And in that event, we'd have to have the second trial where you would decide the question of penalty. Suppose you found that the charge as to Kitty Menendez was manslaughter, the charge as to Jose Menendez was first-degree murder. Of course, it was second-degree murder and manslaughter. That would be the end of it. There would be no further determination of the special circumstance allegation because you'd have a second and a manslaughter. And under the chart, you'd end right here. It's only if you found, for instance, a manslaughter and a first, and in that situation you'd say, well, the multiple murder special circumstance isn't true because we don't have a second. So you would find that to be not true, but your job wouldn't be over because the second charge has been made in this case, and that is the charge of lying in wait. And the special circumstance of lying in wait while lying in wait is a little bit more complicated than the multiple murder special circumstance. And I want to spend just a minute on it, and then I'm through. The instruction says to find that the special circumstance referred to in these instructions as murder while lying in wait is true, each of the following facts must be proved. Number one, the defendant intentionally killed the victim. Number two, the murder was committed while the defendant was lying in wait. The term while lying in wait within the meaning of the law of special circumstance is defined as a waiting and watching for an opportune time to act, together with a concealment by ambush or by some other secret design to take the other person by surprise, even though the victim is aware of the murderer's presence. The lying in wait need not continue for any particular period of time, provided that its duration is such as to show a state of mind equivalent to premeditation or deliberation. Then the instruction goes on to talk about what the term while, that part of the instruction tells you what lying in wait means. That is a waiting and watching together with a concealment by ambush. Now the instruction tells you what killing while lying in wait means. And it says, thus, for a killing to be perpetrated while lying in wait, both the concealment and watchful waiting, as well as the killing, must occur during the same time period or in an uninterrupted attack commencing no later than the moment concealment ends. If there is a clear interruption separating the period of lying in wait from the period during which the killing takes place, so that there is neither an immediate killing nor a continuous flow of the uninterrupted lethal events, the special circumstance is not proved. It's a little bit confusing, but what that means is there are two requirements here: concealment, lying in wait, and that the lying in wait occur while and that the killing occur while the lying in wait take place. And the instruction then sums up what the elements are, and it says, a mere concealment of purpose is not sufficient to meet the requirement of concealment set forth in this special circumstance. However, when a defendant intentionally murders another person under circumstances which include, and now it sets forth the elements that you have to find. Number one, a concealment of purpose. Number 2, a substantial period of watching and waiting for an opportune time to act. And number 3, immediately thereafter, a surprise attack on an unsuspecting victim from a position of advantage. The special circumstance of murder while lying in wait has been established. If the murder is done suddenly, without a period of waiting, watching, and concealment, the special circumstance of lying in wait is not present. So there are two things here. If someone is waiting and watching, and there's a time period between the waiting and the watching and the killing, then the special circumstance is not true, not because there wasn't waiting and watching, but because the killing was not while the person was lying in wait. It has to be both while lying in wait, and there has to be a substantial period of waiting and watching before the killings take place. That's an important distinction to remember in this case if you ever got to that point, and God hopes that you don't, but if you ever got to that point, keep in mind that there are two requirements. It has to flow continuously from the period of waiting and watching into the killing, otherwise it's not while it's lying in wait, and if there's an interruption, then the special circumstance is not true. But more importantly, even to get that far of whether it's while lying in wait, you have to determine that there was a substantial period of waiting and watching for an opportune time to act. That's what a lying in wait means. And the ambush, when Ms. Bozanich says, well, classic lying in wait is where I lie in ambush for you. I wait and watch for you, and when you come by, I kill you. That's classic lying in wait. And she said that she doesn't need classic lying in wait because the killer can come to you now. Well, that's not true. It still is required under this instruction that there be a substantial period of waiting and watching. Otherwise, the special circumstance is not true. And in this case, the prosecutor attempted to prove that charge by cross-examination of Lyle Menendez and by cross-examination of Eric Menendez. And they failed to prove it. And Lyle Menendez, on direct examination, was testifying about the moment in time when he was in the car and the guns were being reloaded prior to going into the house. And he said, I just grabbed a bunch of ammunitions out of the box and I was giving him, Eric, ammunition, and we were just loading as fast as possible. Question, do you remember how many shells you loaded? I don't remember. I remember pulling out all kinds of shells and just loading my gun and having shells on me. Question, what did you do then? We went, my brother, I guess, had got outside through the study doors because he ran toward the study window door, and you had to kind of go over this. I think you had to, we went over the little concrete thing. It was over to the side of the door on the left. And we went through that door and we just went into the room hoping to get there when they were not expecting us. And on cross-examination, Ms. Bozanich asked Lyle Menendez in order to establish that there was a substantial period of watchful waiting. Question, now I take it before you and your brother burst in to kill your parents, you looked through these doors to see what they were doing. Answer, no, we weren't even sure that they were going to necessarily be in that room, but I was hoping. We just burst through the doors, and that's when I saw the shadows of people to the right, and I knew that they were in the room. Question, did you ever think to go into the kitchen and look through the door from the kitchen into that room? Answer, we didn't think we had time to be waiting and looking and stuff. I was just running as fast as I could, and so was my brother. And he got there first, and we just went right through the doors. And as soon as I saw something, I started firing. It was no time to just be watching and trying to see where they were exactly, and so on. And Eric Menendez was questioned along the same lines and gave the same answers. So there is a complete failure of proof in this case to show that there is a substantial period of watchful waiting. The prosecution may direct you to evidence of the statement that Lyle Menendez gave Detective Zoller on September 17th, where he said that my parents sometimes were in the habit of falling asleep. That evidence is contradicted by the maid that they didn't fall asleep in front of the TV. But in any event, that would go to the issue of whether they were taken by surprise. It would not explain the absence of proof on the period of watchful waiting. There is no evidence anywhere other than what I've just indicated to you, which shows that this was a crime, if it was a crime, where someone was watching and waiting for a substantial period of time in order to act. And so there is a complete lack of evidence as to the most serious allegation that was made in this case, which is a special circumstance allegation. I hope I haven't bored you to death with the law, because as I said at the beginning, the law in this case is the second most important thing that you as jurors have to work with in deciding whether the charges are true or not, whether they have been proven beyond a reasonable doubt. And I realize trying to teach you this at 3 o'clock in the afternoon is probably very difficult. You've been an incredibly patient group of people, and patient through all sorts of abusive waits that unfortunately take place when there are so many people involved. I, on behalf of Lyle Menendez, would like to thank you, because I'm not going to otherwise get a chance to talk to you again. And we appreciate your time and your attention. I sincerely believe that you will reach the correct verdicts in this case, and I have no doubt that you will conscientiously weigh and consider the charges and find, after consideration, that Lyle Menendez is not guilty of the charges that have been leveled against him by the prosecution. Thank you.
All right, thank you. And we'll resume tomorrow at 9 o'clock. Again, don't discuss the matter with anyone. Don't form any final opinions about it. Would it be easier for you to come in here at 9 o'clock or the courtroom next door? Or does this matter to you? You want to be? All right, your first chance to make a decision here? Okay. All right. Okay. We got some people want to go over there. Okay, we'll see you tomorrow at 9 o'clock. All right.